Remember your method. Just a minute. Wait for a few minutes. Please take your seat. We'll just come back. Have we informed the other side? Give us a date. You decide when do you want. Give us a date. Please, you decide yourself and let us know. Yes, accordingly we'll fix it. You decide? Yes. Item number? When? The 2018 matter. Common heritage. Item 5. Give us a date. It's a 2018 matter. Give us a date. Hmm? Ninth of November. Not on 16th, 14th. Because if it is left out, then 14 to 16 you can carry forward. Okay? 7 to 11. The prayer of the council for both the parties. Let us be fixed on 14th of November. Item number? Yes. Who is your senior counsel?
JM is JM is not, Your Lordship.
What's your prayer?
Adjourn the matter for today, Your Lordship, kindly, and listed after 2 weeks.
2017 matter. Day after tomorrow.
Your Lordship, it will be difficult for us to get the brief. Your Lordship, after Puja vacation.
No. We'll have it on 5th. Coming week. 5th of March, 5th of November, October.
5th of October.
Let it be on 5th of October. Yes, next. Yes, ma'am.
May I please, Your Lordship? Lordship, I am beg to mention item number 12, Lordship. Already leave note is also given by the engaged council, Lordship. So let this matter maybe come up after vacation. Date may be fixed, Lordship.
Lordship,
You cannot have both. You want it after vacation and you want the date to be
Yes,
fixed.
after
Something like
vacation, Lordship.
Lordship, in this matter, school records are called for. Records are already available with me. So kindly fix a date.
that. 7th of November.
Much obliged.
Yes, Lord, please.
But this is a review matter.
No,
Manoj.
you wanted
Quite
it on
old.
which day?
So I'm available tomorrow if it's convenient to the
No,
court.
difficulty is that bench has to be constituted.
Yes, Lordship. So 10th, I'm here for another case,
10th of October.
October, Lordship. That is a special bench matter. So both benches can be, I can attend both the cases.
Ask your colleague to submit a
Yeah, yes,
slip here
yes,
for fixing the matter on 10th.
much obliged.
Okay.
Much obliged.
Thereafter, we'll ask the authorities.
Much obliged, Lordship. Much obliged.
Yes, ma'am.
My pleasure, Lordship. In this matter, Lordship, petitioner was already on interim and records were called for. Records came, Lordship. But Lordship, while filing this writ petition, we have not annexed the statement of the OP, Lordship. That was in vernacular. So may I file an additional affidavit, Lordship, annexing the statement of the OP, Lordship? Otherwise, 1966-70, his parents' name were there, and 1985, the OP cast his vote along with his father, Lordship.
Statement of the OPs.
Yes, Lordship, that is in vernacular, Lordship.
I don't think so.
We have annexed the voter list of 1966, 70, 85, 97, 2013, and copy of written statement and copy of evidence on affidavit. But cross statement, we have not annexed, Lordship. Annexure 7 is the evidence in chief of opposite party. Page 30.
There was no cross.
Cross is there, Lordship. On 7/7/2017, he was cross-examined. His statement was recorded by the tribunal. In fact, no cross-examination. It is statement of appeal, Lordship. But we have not annexed at the time of filing with the writ petition.
Was the date?
7/7/2017 in the LCR it may be.
Seven 2017.
Yes, Lordship.
Good. Mr. Pine.
Oh, the sheet of fiscal accountability. Page 7 of the
Page 7.
Good.
And also, Lordship, Exhibit 4 is periodic Hiraspatta and Exhibit 5 is Jamabandi, Lordship. Those were also not annexed. Otherwise, all other exhibits 1, 2, 3, 6 and 7 were already annexed, Lordship.
Yes, madam, within how many days will you be able to do it?
After 1 week,
By tomorrow?
by tomorrow,
Not much.
Lordship, by
Or
Thursday,
do you take 1 hour?
Lordship,
Right.
Lordship. Periodic Patta and Jamabandi, I will also annex, Lordship,
Do it.
Lordship. Exhibit 4 and 5 is there, Lordship.
Mr. Pai,
My lord.
will you allow?
Yes, my lord. Otherwise, the already record, my lord.
But it may not have, brother might have
Yes.
difficulty. That's the reason that's
Yes.
a thing. On the prayer of the petitioner, MSR is also. Counsel for the. The statement of the petitioner recorded on 07/07/2017. Which exhibits?
Exhibit 4 and 5, Lordship.
Exhibit 1.
4, Lordship. Periodic Hiras Patta, page 36, Lordship. Of the writ petition, it is mentioned in the impugn order, Lord. LCR, page 20, Lordship.
Writ petition, which page? You have not annexed in the writ petition?
No,
Not in
Lordship.
it.
LCR, page 20, Patta, and page 38, Jamabandi. Four,
Only
5,
those two.
4, 5, and Jamabandi, another Jamabandi, exhibit 9, Lordship. It is mentioned in page 36, Lordship.
Exhibit 4, then
5, then 9.
statement of the petition. As well as exhibit, all small Roman 4, 5, and 9, which are in Vernacular language. Is allowed to be translated to English and to incorporate the same by filing an additional affidavit on or before placed again on 4th of October.
Lordship, next date. Supplies.
Lord, in this case, my lord, that after filing of the requisition, my lord, petitioner has been arrested, my lord. And as such, I have filed the IA, my lord, to release the petitioner from detention camp, my lord. Petitioner was arrested on 7/6/23. Income judgment, my lord, in case 106 of the petition.
Mr. Sharma, who is appearing for election commission today? So, Ali Devil. There is direction from the court to produce the voter list
Lord.
in original. English to be certified by
Give me some time. I will back.
it was already order was passed on 26th of May 2023, fixing the matter on 14th of May, 14th of June.
Matter will be fixed tomorrow, my lord.
Thursday,
Day after tomorrow.
day after tomorrow. See, but if not possible to get it because it might be a bulky one. What is required is that it has to be duly attested by the concerned election officer with full seal and signature and everything. Get it? Because that order is available. Placed on Friday. Enabling the election commission, responding election commission of India to comply with the order dated 26/05/2023. Australia. Yes, Mr. Sharma.
Lordship, we propose this honorable court challenging the order of the honorable Central Administrative Tribunal, Lordship, and this case was heard earlier, Lordship, and it was allowed. Subsequently, the respondents, Lordship, they filed a review petition, and in the review petition, Lordship, it was allowed, and it is before your Lordship now.
Review petition was allowed, so thereafter this is come.
Yes, Lordship, but Lordship in the
It's yeah. Mati pata hai. Why you agree with the order of the learned tribunal?
Lordship, sir, we have paid for HRA for the period with effect from 25/9/2007.
What is the prayer in your application before the tribunal?
Lordship, two prayers were there, Lordship. That Lordship will find page 27.
Hmm.
8.1 to direct the respondent authorities to sanction to the applicant his house rent allowance with effect from 25/9/2007 to 13/7/2009.
Why this period was not allowed?
Lordship,
You didn't get it.
No.
It was not sanctioned.
no.
Okay.
But-
Was any reason given?
The reason was that Lordship, he was entitled to a type 4 quarter and he was holding a type 2 quarter, Lordship. And he, after that Lordship, he released that and went to his personal home, Lordship, that he had built. Lordship. And he had not applied for the HRA immediately after that, Lordship. And in terms of circular of this railway authority, Lordship, he is required to apply for that, Lordship.
So as he did not apply during this period, this particular house rent allowance was not released to him.
That was before the tribunal, Lordship. But subsequently, Lordship, prior to filing of the case before the Central Administrative Tribunal, Lordship, I had preferred applications under RTI, Lordship. Wherein, Lordship, I had sought for information with regard to the vacancy in type 4 bungalows, Lordship. And therein, Lordship, it was stated that there were some type 4 bungalows vacant, Lordship. But then there were applications being filed for allotment of those bungalows, but Lordship, allotment was not given, Lordship. And the reason.
So you filed your applications for allotment of type 4 bungalow, but it was not given to you, or it was not only given to you, but other applicants also.
I filed my application for grant of HRA only, Lordship, not for allotment of type 4 bungalow.
Okay.
The reason behind not granting allotment to those vacant quarters at that point of time. Although applications were being filed by other incumbents who were similarly situated and entitled for type 4 bungalows, Lordship, was not disclosed by
But
the.
whether with regard to those applicants who was also entitled for type 4 quarters, whether they have been provided with HRAs?
Yes, Lordship, that was my contention before.
They were provided with,
Yes.
according to you.
Lordship.
How you have proved that?
Lordship, may kindly peruse the RTI reply, Lordship. At
Okay,
page-
that is one. Second prayer. What is your second prayer?
Lordship, this learned division bench while allowing the review petition, Lordship, recorded only 2 grounds while allowing the review. Lordship, those. So Lordship uses the order dated
In
1/12.
the review.
Yes, Lordship.
Just a minute. Just take your seat.
Lordship, the order dated
Mr. Nair, let him submit.
Let him know. That's why I also wanted.
the order dated 1/12/2022, Lordship. I kindly see it. It's a small order. I am reading the whole one. Heard Mr. So-and-so, learned senior counsel assisted by so-and-so learned counsel appearing for the review petitioners and value authorities. Also heard Mr. Yukenara, senior counsel assisted by so-and-so, learned counsel appearing for the so-and-so. By filing this review petition, the petitioners are seeking review and recall of the order dated 21/5/2018 passed by this court in WBC 2576 of 2016, allowing the writ petition filed by the respondent writ petitioner with a direction upon the authorities to call upon the house rent allowance for the period from 25/9/2007 till 13/7/2009, which amount was held to have been arbitrarily denied to him by the authorities. The order dated 25/5/2018 was based primarily on two counts. Firstly, the learned counsel for the NFLA authorities could not demonstrate before this court that vacant quarters of type 4 category were available during the said period so as to deny the claim of HRA made by the writ petitioner. Secondly, it was observed that by the communication dated 23/3/2011, 15 officers similarly situated as the writ petitioner and enjoying identical pay scales were permitted to draw HRA for the same period, thereby indicating that vacant type 4 quarters were not available during that period. When this review petition was admitted, this court had passed the order dated 31/2019, inter alia providing that the railway authorities would make payment of the amount of HRA new and payable to the petitioner, which would, however, be subject to further orders that may be passed in this review petition. Today, when the matter is called up, Mr. Dasgupta, learned senior counsel appearing for the review petitioners, have submitted that the railway authorities have already paid the HRA amount to the petitioner in terms of the order dated 31/2019. It is also the submission of Mr. Dasgupta that although an answer to both the issues raised in the writ petition were available on the basis of materials on record, yet the learned counsel appearing for the railway authorities had failed to point out the same before the court. Mr. Dasgupta submits that there is proper explanation as to why the 15 officers were allowed to draw HRA, which is on account of the fact that they belong to a separate division of the NF Railway, this construction line of railway, and they were under a different administration, which authority was not included as party to the writ petition, as a result of which the correct information could not be placed before the court. Mr. Dasgupta has further argued that there are materials to show that vacant quarters in the type 4 category were in fact available during the relevant period, and therefore the said aspect of matter ought to have been placed before this court, which could not be done by the learned counsel. On such count, it is submitted that an error apparent on the face of the record has occurred. in the order dated 21/5/2018, which calls for review. Mr. Nair, learned counsel appearing for the respondent writ petitioner, has opposed the prayer by submitting that failure to point out the relevant materials to the court at the time of hearing cannot be a ground to review an order. It is no doubt correct that from the grounds taken in the review petition, we find that there was some lapse on the part of the respondent review petitioners to point out the correct facts before the court. Considering the fact that issue raised by the petitioners counsel has a financial bearing on them and a railway, and in view of the materials placed before us in this review petition, we are of the opinion that for the ends of justice, the matter observed deserves to be revisited without, however, permitting the authorities to disturb the HRA already paid to the respondent petitioner on the strength of order dated 31/2019, unless otherwise directed. In other words, we are convinced that the impugned order dated 21/5/2018 deserves to be reviewed on the grounds noted herein above. So that was the position, Lordship. Lordship, the recovery was not to be done, but the issue was to be heard, Lordship. Lordship, the 2 points, Lordship, in the petition, Lordship, they have contended, Lordship, that paragraph 6, Lordship, will find that. I had said that, Lordship, there are around 7 type 4 bungalows that were they are vacant, Lordship, but there were 8 applicants who had applied for those bungalows, Lordship, but for reasons based to the known to the authorities, Lordship, those bungalows were not being allotted at that point of time, Lordship. So, those quarters were not fit for occupation, Lordship.
Just a minute. Just take your seat.
Lordship, the stand of the railway authorities before the learned tribunal with regard to the vacancy position was that there were 4 quarters vacant at that point of time.
No, their stand is that till you, when till the date when the quarters are available, not to pay the house rent. Only during non-availability of such quarters will be paid the house rent allowances. But it will be reviewed again if in between, if it is found that there are vacant quarters available, then again so that power was given to the railway to review its matter. But the stand according to their notifications is very clear that as long as the quarters are available, those bungalows are available, will not be paid house rent allowances.
That's what the case is, Lordship. There were vacant quarters available at that point of time. That fact is not denied by anybody, Lordship. But those quarters were not fit for occupation, Lordship. That is my stand, Lordship. Because, Lordship, applications were pending at that point of time for allotment of those quarters, but they did not allot, Lordship.
See, was that issue raised before the tribunal?
Yes, Lordship.
What is the finding of the tribunal in that regard? Now, that shows in your application before the tribunal. That
Yes,
you have taken that
Lordship, may
ground.
kindly peruse page 91, Lordship, once. Prior to that, Lordship will peruse page 55 once, Lordship. That is the affidavit filed by the respondent number 1 and 2 in the before the CAT, Lordship. And therein the vacancy position was stated by themselves, Lordship.
Tell us.
Page 55, paragraph 5. That with regard to the statements made in so and so of the original application, the answering respondent, while denying the contention made therein, begs to state that the applicant, by virtue of his designation / grade pay, that is the Group B officer, is entitled for type 4 bungalow at the relevant point of time. there were 4 numbers of type 4 bungalows lying vacant in the Maligaon area. Therefore, in view of the Railway Board Circular dated 9/5/2003, the applicant must submit application for allotment of type 4 bungalow, and till such bungalow are lying vacant, inquiry could not be permitted in the case of the applicant. The last type 4 bungalow amongst the 4 vacant bungalows was allocated on 14/7/2009. Therefore, the applicant is entitled for grant of HRA with effect from 14/7/2009. The Railway Board Circular dated so and so shows that the staff with grade pay more than ₹4200 are entitled for type 4 bungalows. So that was the position before the landed tribunal lecture. And page 91 is it's an RTI reply, Lordship. The number 1 point against which information was sought was replied in, the question was, Lordship, the information sought for was, Lordship, number 1 at page 91, Lordship, was how many officers, both open line and construction organization, who applied for allotment of type 4 bungalow in Maligaon area were awaiting allotment allotment of such railway accommodations as on 25/9/2007. The reply was, Lordship, there is no really available information, but
Which page? That annexer R2?
page 91, Lordship, of the appeal, with petition, Lordship. This is the RTI reply, Lordship. I am reading it again, Lordship. The number 1 information was how many officers, both open line and construction organization, who applied for allotment of type 4 bungalow in Maligaon area were awaiting for allotment of such railway accommodations as on 25/9/2007. The reply was that there is no readily available information, but after searching out old records with effect from January 2006 to 25/9/2007, the list of officers who had applied for type 4 bungalows annexed as Annexer 1. Out of this list, as per available records, the officers who were allotted and occupied bungalows are given in Annexer 2. However, the list of bungalows is always updated in computer and no old record is available in computer. If you like to inspect the files also, you would do so in our office in any working day prior to intimation, 1 day in advance. So now Annexer 1, Lordship, that was Lordship, it's at page 93. It's a list containing 34 incumbents, Lordship. Meaning thereby, Lordship, there are 31 officers who had applied, Lordship. 34 officers who had applied. And Lordship, Annexer 2 is at page 95. It contains a list of 22 incumbents, Lordship. Now, out of those 34 who had applied, 22 only could be given accommodation, Lordship. And the rest 4 bungalows which were stated to be vacant were lying vacant, Lordship, even though applications were pending. Because those were not fit for occupation, Lordship.
So according to you, 12s are not fit for occupation.
No, Lordship. No, Lordship.
Now just tell us one thing.
Lordship.
According to the railways in their review petition,
Lordship.
contention is that Austrian allowances were paid to someone in spite of the availability of the quarters. But they belongs to a different category, civil, and they were not made parties. Right? That's what is one of their stand for review.
Lordship.
Now, according to you, as on 25/9/2007,
Lordship.
right? There was only one application. Serial number 33 at page 94. All are prior to that. Rest all are prior to that.
But those were pending, Lordship.
Still. They're pending since 9/1/2006.
Lordship.
Out of this 34,
From the list itself, Lordship, the annexer 2 that was annexed, Lordship. From that list only, some were given allotment, Lordship. Those, in the annexer 1, the incumbent at serial number 3 was the first one in the annexer 2, Lordship.
that's right.
And similarly, Lordship, the second one in the annexer 2 is at serial number 5 in annexer 1. And all those incumbents appearing in annexer 2 were from the list in annexer 1 itself, Lordship.
From where you are saying
Lordship,
that out of those 35 applicants, 34 applicants,
Lordship,
only 22 quarters are available.
22 incumbents were given allotment, Lordship.
Type 4 quarters given to 22.
In the RTI reply, Lordship, page 91, Lordship, it itself says that, Lordship. The number 1, Lordship, reply. There is no readily available information, but after searching out old records with effect from January 2006 to 25/9/2007, the list of officers who had applied for type 4 bungalows annexed as annexer 1. Out of this list, as per available records, the officers who were allotted and occupied bungalows are given in annexer 2. So that was what was finding structure.
So what do you want to establish from this?
There were 34 applications pending at that point of time as on 25/9/2007. But only 22 incumbents could be given allotment, Lordship, although the quarters were lying vacant, Lordship. Bungalows were lying vacant, type 4 bungalows.
Okay. Then
Subsequently, Lordship, number 2, with regard to the query number 2 at page 91, Lordship, they give out the bungalows, those were vacant, Lordship. That they have stated in the affidavit also, that 4 were lying vacant. I had sought for the name and designation of the serial number 3, Lordship. I am reading it up. How many type 4 bungalows entitled for allotment to gazetted officers were there in Maligaon area as on 25/9/2007? List all these bungalows along with names and designations of the officers who were in occupation of these bungalows as on 25/9/2007. May please be furnished. The reply was the list of type 4 bungalows in so and so area with occupants as on 25/9/2007 is attached as annexer 3. Annexer 3. Is 96 Lordship.
yes,
Not 96, it's 99 probably, Lordship.
96. Page 96.
Is 99 probably is the least, Lordship. The pay scale were similar. they were entitled to type 4 bungalows, Lordship. So out of this list, Lordship, the incumbent at serial number 3 and serial number 4 were similarly placed to that of the applicant in the OA, Lordship. And
You couldn't get it.
they were drawing HRA at that point of time, Lordship, during that period, Lordship. Page 99, serial number 3 and 4.
Kindly name.
It's Escalata and SN Gupta, Lordship.
You are under S&T department.
It's within code.
There are engineering department, S&T department, and electrical department. Page 99.
Lordship. Yes,
So you want to show that 3 and 4 under S&T department?
we're drawing similar pay scale to that of the petition applicant, Lordship.
8,000 to 13,500.
Lordship.
They were provided with substantial lands.
Yes, Lordship. And that fact was brought in the review petition also, Lordship. It was considered. It's at paragraph 6, Lordship. Page 5 of the review petition, if Lordship, there is just one, Lordship,
Page 5.
of the review petition. Paragraph 6. That the review petitioner state that the respondent review petitioner in support of his claim for HRA with effect from 25/9/07 relied on a communication dated 23/3/2011 reflecting payment of HRA to 15 persons during the period 25/9/07 to 14/7/2009. The respondent review petitioner contended that if those 15 persons enjoying identical pay scale were permitted to draw HRA, then denying him HRA for the period amounted to discrimination in contrary to the vacancy position of type 4 quarter as projected by the railway authorities. This honorable court accepted such contention and recorded in the judgment dated 21/5/2018 the following observation. Not only Dr. Gogoi has failed to give any convincing answer to our query as to how 15 officers referred to in the departmental communication dated 23/3/2011 enjoying identical pay scale were permitted to draw HRA during 25/9/2007 to 14/7/2009 if type 4 quarter were in fact lying vacant during that period. In this regard, the review petitioner states that the communication dated 23/3/2011 would make it clear that the persons concerned were all from the construction line of railway, and the detailed particulars of those persons were not available during the hearing of this case. In response to a letter dated 6/7/2018 bearing so and so of DGM so and so, the Deputy CPO Construction Malika provided a verification report regarding payment of HRA to those 15 persons. By this letter dated 3/8/2018. From the same letter, it transpires that the person placed the serial number 2, 3, 5, 6, 11, 12, and 14 of the communication dated 23/3/2011 were placed at a higher scale than that of the respondent review petitioner and were entitled to type 5 quarter. Persons at serial number 2, 3, 5, and 6 were drawing HRA from the period prior to January 2007, and persons at serial number 11, 12, and 14 were getting HRA from December 2008, June 2009, and 26/3/2009 respectively. Hence, grant of HRA to those persons having different entitlement of type of quarter and for a different period, having no bearing with the case of the respondent repetition. Such payments do not reflect non-availability of type 4 quarter in Maligaon area. The letter further provided that persons placed at serial number 9, Sri P.K. Deka was posted at Silsar, deputy so and so at the 11th point of time and drawing HRA with effect from 16/6/2009. Hence, grant of HRA to him is different from that of the respondent lead petitioner and has no bearing with vacancy of type 4 quarter at Maligaon. Similarly, the person at serial number 13 was posted as OSD in Kolkata under Eastern Railway and was drawing HRA from 2/3/2009. Hence, grant of HRA to him has no relevance with vacancy position of type 4 quarters in Maligaon area. Now, Lordship, they say this portion is important. Lordship. So far, the other person placed the serial number 1, 4, 7, 8, 9, and 10, they were receiving HRA prior to 2007. Hence, grant of HRA to them have no bearing on the vacancy position of type 4 quarters in Maligaon during the period commencing from 25/9/2007 to 14/7/2009. That is the claim of HRA of the writ petitioner / writ petitioner. As regards the person placed at serial number 15, it appears that the person was wrongly granted HRA. So this was similarly situated. With on 5/1/2009 with effect from January 2008 without certification of DGMG. Accordingly, steps for recovery of HRA wrongly paid to him is being contemplated. Thus, an overall reading of the verification report would go to show that HRA were paid to 14 such persons for different reasons having no nexus bearing with the entitlement of draw HRA for by the respondent petitioner and or in contrary to the vacancy position of type 4 quarters as indicated earlier. So they themselves admitted, Lordship, that at least one person was similarly situated at that point of time who was drawing.
So if you are wrongly given, that also should be given to you.
No, Lordship. I am not saying that at only one person, Lordship. The other persons who are there, they are also drawing the similar pay scale, Lordship, and they were, most of them were posted in Maligaon area, Lordship. Only in respect of one at serial number 2, 3, 5, 6, 11, 12, and 14, and serial number 9, Lordship, they were posted outside, Lordship.
Five, 6, 11, 12, and 14, and 9 was posted at Calcutta, I believe.
Yeah.
13 was posted at Calcutta.
9 Silchar.
Now, Mr. Sharma, tell us these 1, 4, 7, 8, 9, and 10,
Lordship.
whether they have been granted such Australian alliance with effect from 25th of September 2007 or not.
Lordship, the basic dispute here is that they say that, Lordship, I need to apply for that, Lordship, for the allotment of the party, Lordship. But I was given HRA with effect from 15/7/2009 without even applying, Lordship. But they denied my payment prior to that, Lordship. They say that it was the bungalows were remaining vacant, not. There was
No, you have been given from 15/7/2009 because of the order of the dependents of this court earlier past or after the order of the tribunal. You are
no,
asking for May 2007, right?
Lordship.
To September, 10th of September. You are receiving from, you want from 25th of September 2007 to 14th of July 2009.
Lordship.
That should be.
There was no order passed by. Without interference of this court, they gave me that, Lordship. With effect from 15/7/2009.
What is the procedure? Or what is the notification by which the person is entitled for HRA? Is there any specific notifications?
Circular is the lordship.
Page 31.
Page 31 lordship.
Of the read petition.
Yes, lordship.
This is the circular.
Yes, lordship. Where is lordship?
Just a minute. Yes.
Lordship. I'm reading from in terms of
Yes, yes, from read from that.
in terms of instruction contained in ministry letter number so and so dated 10/7/67 in supervision of provisions contained in rules 4161, 4171 and 4172 B1 1971 edition, it was decided that railway servants who are eligible for railway accommodation who want to submit application for such accommodation or who are submitting applications for such accommodations refuse to accept accommodation when offered allotted, or who after having accepted such accommodation surrender it may be paid house rent allowance if otherwise admissible, provided that number 8, those referred to in 2 and 3 will have above will not be considered again for allotment of railway accommodation for a period of 1 year from the date of such refusal or surrender. And number B, the number of units available for allotment does not exceed the number of eligible employees, and there is no prospect of any residential unit remaining vacant as a result of such refusal, surrender, or non-application for accommodation. This was relevant, lordship, because number B, lordship, they say that the bungalows were vacant, lordship, and I said that those are not fit for occupation, lordship. And now page 32, paragraph 3, it's also relevant. It was further clarified in this ministry letter number so and so dated 29/8/68 that in the case of surrender of accommodation, house rent allowance, if otherwise admissible, would be payable from the date it is certified by the accommodation controlling authority that no accommodation in the entitled class is available for allotment. They certified in my case that it is with effect from 15/7/2009. So I was granted in the HRA with effect from that date, lordship. And number paragraph 6, lordship, in page 32. In case after issue of orders, it transpires that some accommodation is likely to remain vacant, unoccupied due to lack of demand, the orders should be reviewed and it should be made compulsory to submit applications for such types which there is surplus accommodation, and consequently the employees entitled for such types would not be eligible to draw house rent allowance. They applied this logic. But my contention with regard to that point number 6 is that even on 15/7/2009, when I was granted HRA, I did not submit any application with regard to allotment of type 4 bungalow.
Read that proviso very slowly, A and B.
Those referred to in 2 and 3 above,
See, basically there are three categories, right?
lordship, who do not submit applications for such accommodation.
That is one category.
Yes, lordship. Who after submit, Lordship. Those
It
record,
was decided that railway servants who are eligible for railway accommodation and who do not submit application for such accommodation.
number A, Lordship, those referred,
Don't go for that.
no, Lordship,
May be paid, straight away come to the last line of the first paragraph.
Lordship,
May be paid, because there are three categories. You just only read the first category.
Lordship.
According to you, you have not filed any application.
Yes, Lordship.
So you come to this category. Who do not submit application for such accommodation may be paid house rent allowances.
Maybe, yes, Lordship, if otherwise admissible, provided that
Now read this.
B,
A, you read.
A is with regard,
Those two and three
to,
not applicable in your case.
yes, Lordship.
B,
The number of units available for allotment does not exceed the number of eligible employees. And there is no prospect of any residential unit remaining vacant as a result of such refusal, surrender, or non-application for accommodation.
so they will be subject to number of units available for allotment
Does not exceed
exceed the number of eligible
eligible
employees. So according to you, as per the annexure 1, there were 34 applicants at the relevant point of time,
Lordship.
right? And 22 were provided with the quarters,
Yes, Lordship.
right? So if it is a fact that when 34 were applicant as on particular date and 52 were provided, then see, there is no prospect of any residential unit remaining vacant
As a result of such refusal, surrender, or non-application for accommodation.
Now, with this, what is the stand of the railway?
That they have stated in their affidavit, there were 4 vacant quarters. Lordship. Paragraph 5, page 55.
But your second RTI clause,
Yes, Lordship,
they have given the dates, in the second application, because it's quarters, 4 quarters they have shown. You ask for how many quarters vacant at Maligaon, so they have given 4 quarters respective dates. Okay, then, but those dates are not from 2007, I believe, it's 91.
prior to the Lordship. Page 91.
Please come. 91, second one. Number 2.
Number 2 is from 4/4/2008 to 8/4/2009. Then the second one, 2/1/2008. Third one is also from 2/1/2008. And the fourth one is 22/4/2006 to 7/7/2008.
So at least one particular quarter was available from 22nd of April 2006 to 7th of September, 7th of July 2008. After the date of 25th of 9, 2007.
Lordship.
There are 2 other quarters in others colony, I believe.
Yes, Lordship.
31/2007 and 16/8/2006. Now, just tell us, in compliance of this particular circular, these 3 quarters were available
Lordship.
during the period, at least when you applied for it, is 25th of September 2007.
For HRA.
So
They did not act any on that, Lordship. Either they granted HRA nor they said that you need to make an application for allotment of quarter.
even if you do not make an application,
Lordship.
there has to be, if there is no surplus, then only will be paid. Yes.
Lordship.
But at that point of time, these quarters were available.
Lordship.
If you forget 2 and 3, first proviso, before the proviso A and B, if you read the first, because you will come under 1, the first category, which you have not applied for. And you will be provided with house rent allowance, will come under B category, proviso B. Proviso B, you read again.
The
Page
number
31.
Page 31.
The number of units available
available for allotment
allotment does
exceed
not exceed
the number of eligible employees, and
and
there is no prospect of any residential unit remaining vacant as a result of such refusal, surrender, or non-application for accommodation.
if these three, if there is no prospect for any residential unit remaining vacant. But those were vacant.
Those were vacant, Lordship.
So
Lordship,
if those were vacant, whether you will be entitled for HRA.
yes, Lordship.
That will
That's
reply-
that's what I want to explain, Lordship. If Lordship uses page 93 once, Lordship,
Yes.
Lordship will see the date of application once, Lordship. Those were pending since 2006 till 24/9/2007. But they could not allot, Lordship. The reason was also not disclosed, Lordship. The fact was that, Lordship, those are still, there are some quarters I have seen, Lordship, those are still remaining vacant, Lordship, and very dilapidated condition, Lordship. No one wants to stay there, Lordship.
Thing is like this.
Lordship,
Normally you apply,
Lordship.
what's allotted to you, and the quarter is in a dilapidated condition. You ask the civil engineering department before handing over to you, you should make this correct. You restore this to you so that you can form human habitation. Whatever repairing is to be
No.
done, they will do.
Lordship.
But you are a person who have not applied for any such accommodation. Staying in your own house, right? Since you are not asking for any accommodation, at the same time, you are seeking entitlement under HRA. Now, HRA will be given when there is no surplus. Even if you do not apply, and there is no such quarters available for allotment, then you are entitled for it. One condition.
Lordship.
Second is who after submitting application for such accommodation refuses to accept the accommodation. Right?
Lordship. First, they will have to give us the accommodation, Lordship.
When did you apply? Your case is totally different.
Lordship.
You have not applied. And in that circumstances, proviso B.
Lordship.
Now, what as per your RTI application, you have come to know that certain point of time, certain accommodations were available during that period,
Lordship.
right? Now, question of some quarters were not allotted to someone in spite of being there vacancy. It's something else because we are not on that. You are entitled for HRA only in terms of this particular circular.
Lordship will also peruse paragraph 3, Lordship, because I was occupying
Yes,
a type 2 quarter, Lordship,
Yes.
and I surrendered it. Page 32, Lordship. It was further clarified in this ministry letter number so and so dated 29/8/68 that in the case of surrender of accommodation, house rent allowance, if otherwise admissible, would be payable from the date it is certified by the accommodation controlling authority that no accommodation in the entitled class is available for allotment.
But it was available for your class. Quarter 4 was available. Type 4 quarters were available.
Quarters were available.
Then
Lordship.
you were earlier on a type 2 quarters. Now, as per your placement, you are entitled for type 4 bungalows. Right? Since you've been promoted, you have become a gazetted officer, you have been higher pedestal, so necessarily you have been now entitled for type 4 bungalows.
Lordship.
And that is why you have surrendered type 2 quarters.
Lordship.
The
Facts are-
reason that you have your own accommodation, that is a different.
Lordship.
Now, here, that whether you are entitled for X-ray on during that period or not. So without your application, you forget the clause 2 and clause 3. You will have been entitled for X-ray only when there will be no surplus available quarters for your allotment.
My case was that, Lordship. That of course the circular says, Lordship, but
Can we go beyond the circular? You are entitled for X-ray only on the basis of the circular. Tell us.
specific, what had happened, Lordship, those quarters were remaining vacant, Lordship. Applications were
You can
there.
understand that without your application, let us assume you have applied for. And a quarter is available, quarter is allotted to you. Will you take it?
They does not give allotment of those quarters, Lordship, and they themselves assume that those quarters are not there only, Lordship, because Lordship, they allowed other incumbents who were in a similar category to draw HRA during that period of time, Lordship. And that is reflected in their
Was it
RTIs.
a case before the tribunal?
Yes, Lordship. Lordship may kindly peruse the order once, Lordship. That was their Lordship, our good Lordship, but probably not considered, Lordship. Paragraph 10, Lordship will read at page 113. The circular was herein discussed, Lordship, at paragraph 9.
Just a minute.
I'm reading it, Lordship.
Just a minute, Mr. Sharma. Coming back to you. Please take your seat. Yes, where is the order of the tribunal?
starts. At page 108 it starts. The circular lordship has been discussed at paragraph 9, page 112. Lordship, otherwise paragraph 7 is also relevant, Lordship. May I read from paragraph 7? According to the Railway Council, as per the above para, it is an officer, if an officer is entitled for a type 4 bungalow by virtue of his designation, grade, pay, and if there are several type 4 bungalows lying vacant, unoccupied due to lack of demand. In such eventuality, the officer, as per the mandate of the aforesaid circular dated 9/5/2003, would have to submit application for allotment of type 4 bungalow. If the officer concerned does not submit such application, he would not be eligible to draw HRA. The Learned Counsel further submitted that the applicant, by virtue of his designation grade B, that is Group B, officer was entitled to a type 4 bungalow, and at the 11th time, there was 4 type 4 bungalows lying vacant. Therefore, according to the Learned Counsel, in view of the circular dated 9/5/2003, the applicant was required to submit application for allotment of type 4 bungalow. Until such time the bungalow was lying vacant, HRA could not have been allowed in the case of applicant. Learned Counsel further submitted that last type 4 bungalow amongst the 4 vacant bungalows was allotted on 14/7/2009, and therefore the applicant was entitled for grant of HRA with effect from 14/7/2009. According to the Learned Railway Council, as per Railway Board Circular dated 27/1/2011, staffs with grade pay of more than 4,200 were entitled to grade 4 bungalow. Learned Council further submitted that as per Circular dated 9/5/2009 and Circular dated 7/6/88, the applicant was not entitled for grant of HRA till a type 4 bungalow to which he was entitled to by virtue of his grade pay was lying vacant. Accordingly, by the order dated 16/7/2009, the applicant was granted HRA with effect from 14/7/2009, on which date the last type 4 bungalow was allotted. As far as the information regarding results for granting the applicant HRA with effect from 14/7/2009 sought for by the applicant, filed his RTI application dated 16/2011 is concerned. Learned Railway Council submitted that the DGMG from PIO Maligaon had already furnished reasons for his communication dated 3/5/2011. Learned Council submitted that the applicant has deliberately suppressed his RTI application dated 16/2/2011, as well as the reply furnished by the DGMG from PIO, which according to the Learned Council would have been a material fact in deciding the issue involved in the instant case. We have heard the Learned Council peruse the materials, pleadings and materials on record, and the precedents relied on. The main issue in the present case relates to grant of HRA with effect from 25/9/2007 to 14/7/2009. The senior section engineer works, NF Railway Nambari Guwahati by letter dated 27/9/2007, Annexure 1 of the OA, informed the DGMG Maligaon NF Railway that the applicant had vacated his quarter number 77A type 2 at Nambari, and it was handed over to the senior section engineer works without electrical fitting on 21/9/2007. In the same letter, it was further stated that there was nothing outstanding against the applicant towards the building concerned. The Chief Personnel Officer NF Railway by circular dated 7/6/88 on the subject of admissibility of HRA in the event of non-acceptance or surrender of railway residential accommodation had communicated to all heads of department and concerned the instructions of the railway board as extracted below. That was the one that was discussed in the circular
Page 31.
Page 31.
Of the circular, which
Now, where is paragraph 10 lordship? I will repeat that lordship.
It's 31 what?
Lordship.
No,
It is the circular. That circular which the lordship has read earlier has been quoted here.
here,
In the order.
In the order.
in the order.
May I read paragraph 10 now, lordship? Or else
Please go ahead.
the applicant did not make representation on 27/9/2007 to the respondent authorities with a request to grant HRA as per extant rules. In 16/7/2009, accorded sanction of HRA in favor of applicant with effect from 14/7/2009, which is annexed as Annexure 4 to the OA. Thereafter, the applicant submitted several representations before the authorities praying for grant of HRA with effect from 25/9/2007. That is the date of occupation of the quarter by the next LOT as per rules. The applicant also submitted an RTI application dated 6/12/2012 seeking certain information, and the respondents filed letter dated 13/3/2013 furnished a copy of the reply to the applicant wherein against his query regarding reasons for disallowing his claim for HRA with effect from 26/9/2007 to 13/7/2009, the DGMG cum PIO NFLA Malika replied as hereunder. You have not sought any available information. Reason is not covered under RTI 05. Paragraph 11. It appears from the noting at PP 114 dated 9/3/2010 Annex 13 of the to the OA. The DGMG had approved certified the payment of HRA with effect from 14/7/2009 to the applicant. The DGMG file is noting at PP 115 dated 6/5/2010 has stated as follows. Given HRA from the date the last quarter's lying vacant was occupied by officer. The other officers who had been sanctioned HRA is not in my knowledge before the date 14/7/2009. Paragraph 12. On 9/5/2003, referring to board's letter dated 16/6/1988 and others, the joint director established Railway Board Ministry of Railways wrote to the General Manager of All India Railways and Production Units, etc. on the subject of admissibility of HRA in the event of non-acceptance to or surrender of railway residential accommodation. At paragraph 3 of the aforesaid letter dated 9/5/2003, it is stipulated as follows. In case at any point of time it transfers that some accommodation is likely to remain vacant, unoccupied due to lack of demand, it should be made compulsory to submit applications for such types where there is surplus accommodation, and consequently the employees entitled for such types would not be eligible to draw house rent allowance.
Page 61.
Paragraph 13. In the present case, it is not disputed that the applicant who was entitled to for type 4 quarter did not apply for any quarter after surrender of the earlier quarter on 21/9/2007, which was occupied by one Abul Nasser, the next LOT of quarter number 77A type 2 with effect from 25/9/2007. In order to ascertain whether there was some accommodation lying vacant, unoccupied due to lack of demand, at the relevant period, we would refer to letter of the DGMG come PIO dated 3/5/2011 in reply to the RT application dated 16/2/2011 submitted by the applicant seeking certain information. Against queries contained in paragraph 2 and 3 of the replies furnished by the department are as follows. That lordship had already seen earlier. Paragraph 15. Thus, from the above reply of the department, it is seen that there was a type 4 quarter lying vacant during the period in question. The applicant in present case did not place the reply before the court, although the same was in reply to his RTA application dated 16/2/2011. Therefore, the stipulation under paragraph 3 of the circular dated 9/5/2003, which was in operation at the relevant time, would be applicable in the applicant's case for grant of HRA to him with effect from 14/7/2009. Moreover, the circumstances prevailing at the relevant time, as communicated by the department by letter dated 3/5/2011, in reply to the applicant's RTA application dated 16/2/2011, corroborates the stand taken by the respondent authorities. In view of the above circumstances and after taking consideration of the entire conspectus of the matter, we are not inclined to interfere with the decision of the respondent authorities to grant HRA to the applicant with effect from 14/7/2009.
Period. From twenty-fifth of September 2007 till the date you have been paid your housing allowance on 14/7/2009. Was there any other circular?
Paragraph 12, lordship. This was just a clarification, lordship. Paragraph 12, page 113.
Yes.
Lordship will find it. On 9/5/2003, referring to Railways Board letter dated 16/6/1988 and others, the Joint Director established in PNA Railway Board, Ministry of Railways, wrote to the general managers of all Indian Railway and production, etc., on the subject of availability of HRA in the event of non-acceptance or surrender of railway residential accommodation. At paragraph 3 of the aforesaid letter dated 9/5/2003, it is stipulated as follows. In case at any point of time it transpires that some accommodation is likely to remain vacant, unoccupied due to lack of demand, it should be made compulsory to submit applications for such types where there is surplus accommodation, and consequently the employees entitled for such types would not be entitled to draw HRA, house rent allowance. That was supplementing.
And that circular lordship will find at page 61 of the petition.
No, it's okay because that is only supplementing the previous, it is of the supplementary.
Lordship
Circular
will
of 7680.
find, see the wordings once, lordship. It, in case at any point of time, it transpired that some accommodation is likely to remain vacant, unoccupied due to lack of demand. Now, lordship, it should be made compulsory to submit applications for such types. So it was compulsory, lordship, but they, even after I preferred representations coming again, lordship, they did not even make any communication regarding making an application with regard to applying for that accommodation.
That, if you come to page number 61. The petition, that's in a circular annexed, circular of 9/5/2003 of the respondent railways in the written statement.
Paragraph
Para 3.
In
They have
case,
clarified about this. See, there are, if you read the para 3,
in case at any point of time, it transpires that some accommodation is likely to remain vacant, unoccupied due to lack of demand, it should be made compulsory to submit applications for such types where there is surplus accommodation, and consequently the employee entitled for such types would not be eligible to draw house rent allowance.
so first of all, they have to come to the conclusion, the railways have to come to the conclusion that due to lack of demand,
Yes, sir.
those quarters, surplus quarters are vacant
Yes.
or unoccupied. Then only it should be made compulsory to submit applications for such types, that is quarters, where there is surplus accommodation. Suppose the petitioner, the railways did not in their reply, did not indicate that whether at that point of time there was such surplus vacancy of type 4 bungalows, right?
Lordship.
And due to lack of demand, those surplus type 4 bungalows remain vacant or unoccupied.
Lordship.
In the reply filed by the railways,
There is nothing.
it is nothing. There is no mention to that regard of the clause 3 of the circular of 9th of May 2003 at page 61. You don't come under, let us say you don't come under this category. Even then you will come under the category at page 31.
Lordship.
Now, if you come under page 31 category, will you be entitled? Forget the 61 circular, because the railways did not state anything,
Lordship.
that there are surplus quarters, but there is a lack of demand. Up to September 2007, we have shown there are 25th of September, there was demands were there. In their reply, they have stated, the RTI reply, they have stated the list there is given to you. Next one. But we are not saying anything with regard to that because they have not seen that text. But what about the second proviso?
Lordship, this,
Will you able to overcome this? You will be provided with house rent allowance.
this was also a circular on the Lordship. That at,
Circular, that's what we are entitled for HRA.
And the one at page 61, Lordship, is also a similar one, Lordship. But herein the wordings are different, Lordship.
So what we are saying, clause 3 is very clear in the subsequent circular at page 61. That if there are surplus available quarters, right?
Lordship.
And they remain vacant due to lack of demand. Then in that case, if somebody doesn't file any application,
Lordship, may kindly peruse paragraph 2 of the circular page 61, Lordship.
Really, that has been considered.
Yes, Lordship, the earlier circular was put in the reference, Lordship. And paragraph 2, Lordship. The question of renewing this delegation of power beyond 31/3/2003 has been engaging the attention of the board on the basis of the
Why don't you
report.
read the entire,
Lordship, I'm
that will be
reading
better for you.
Lordship, I'm reading from the beginning. Attention is invited to board's letter quoted above, delegating powers to the general managers and heads of organizations, directly controlling allotment of quarters to railway servants for sanction of each house rent allowance in accordance with the prescribed conditions to the categories of railway employees specified therein. The delegation of powers was valid up to 31/3/2003. The question of redoing the delegation of powers beyond 31/3/2003 has been engaging the attention of the board on the basis of the reports received from the Zonal Railways and Production Units. The matter has been considered and the board have decided to renew the sanction contained in paragraph 3 of the letter stated 16/5/1988 and was amended, modified from time to time with effect from 1/4/2003 up to 31/3/2010. Whereafter, the question of renewing the delegation will be considered by the board and a fresh sanction, if necessary, issued on the basis of the reports received from the general managers, etc., directly controlling allotment of quarters in regard to the position of availability of railway accommodation under their control.
So by this, up to 31st of March 2010, power was given to the
General-
general, this is general manager and the heads of the organization,
Lordship.
right? Regarding the allotment of HRA or whatever. That clause 3,
Clause 3. In case at any point of time it transpires that some accommodation is likely to remain vacant, unoccupied due to lack of demand.
this is first criteria. If it is come to the notice or transpires that some accommodation is likely to remain vacant or unoccupied due to lack of demand. That means there is no demand for quarters. Then
It should be made compulsory to submit applications for such types where there is surplus accommodation.
so it should be made compulsory to submit applications for such types, that means the quarters, where there is surplus accommodation. So those who are entitled for particular types of quarters, if those quarters are remain vacant or unoccupied due to lack of demand, then it should be made a compulsory. It should be made compulsory for them to submit applications for the quarters, right?
Lordship.
Types of quarter as they are entitled for,
And consequently,
where there is surplus accommodation, right? Then consequently,
the employees entitled for such types would not be eligible to draw house rent allowance.
so consequently means if you do not file applications, the employees entitled for such types would not be eligible to draw house rent allowances.
This clause will come in.
According to the railways, this clause will come in. But you just see, some accommodation is likely to remain vacant, unoccupied due to lack of demand. This particular, it has to come, it has to be transferred by the railways. If we follow this particular circular filed by the railways, there is no such mention that it has come to their notice or they have transpired that due to lack of demand, these quarters are lying vacant. If only the railway comes to the conclusion that these type of quarters are lying vacant due to lack of demand. Then only the consequential effects are will be there. That means there has to be an application. And if there is no application, then HRA will not be provided to that particular person who is entitled for the quarter. But there is no such finding on the part of the railways that there was lack of demand. Please saying that is because circular you have to read as a whole. There is no finding from the railway. There is lack of demand. There may be vacancy. There may be vacancy, but there was no finding that there was lack of demand. But whether in that circumstances you come under page 31 or not.
Lordship, the order of the Landed Tribunal, Lordship, therein at paragraph 14, Lordship, the subsequent thing was also discussed, Lordship, that there were quarters remaining vacant at that point of time. But that lack of demand thing was never discussed, Lordship. And Lordship, if Lordship peruses the
Let us see the affidavit of the railway. Whether there is any finding to that extent.
it's not there, Lordship, but when
Yes,
allowing the repetition, Lordship, on the 21/5/2018, this thing was being considered, Lordship.
yes. First occasion.
Yes, Lordship. And, paragraph 6. But yeah, I read at page 18 of the no, it's a the order dated
21st of May 2018.
it's in the internal page 3. Internal
Now
page
which para?
paragraph 6.
Yes.
Yes, paragraph 6, Lordship. By referring internal page 3. Yes, Lordship. 21st of May 2018. By referring to the pleadings contained in paragraph 4.11 of the application filed before the tribunal, Mr. Nair has further contended that the specific statement of the petitioner to the effect that no quarter in the type 4 category which was fit for occupation by the officials was available during the period from 25/9/2007 to 14/7/2009 has been denied by the respondents in their written statement. Under the circumstances, Mr. Nair, the improved judgment and order dated 31/2015 passed by the Landed Tribunal is vitiated by complete arbitrariness and non-application of mind and therefore calls for interference by this court. Then Lordship will read paragraph 9, Lordship. There is no wrangle at the bar that the petitioner was entitled to a type 4 quarter, but it was only on account of non-availability of the same. He was allotted a lower grade quarter, which is of type 2 quarter category. There is no dispute that the fact that the petitioner is receiving HRA as per his entitlement since 14/7/2009. Therefore, the only issue that arises for adjudication in the present writ petition is as to whether the petitioner would be entitled to claim HRA for the period from 25/9/2007 to 13/7/2009. It appears from the record that the Chief Personnel Officer NF Railway has issued a circular on 7/6/1988 inter alia laying down the railway servants who are eligible for railway accommodation and do not submit application for such accommodation, or who after submitting such application refuses to accept accommodation or surrender it, may be paid HRA if there is no prospect of any residential unit remaining vacant as a result of refusal, surrender, or non-application for such accommodation. It further appears from the records that on 23/7/1999, another notification was issued by the Railway Board dealing with the issue of payment of HRA to the employees. Paragraph 5 of the notification would be relevant for this case and is therefore quoted. Herein below. In the case any point of time it transfers that some accommodation is likely to remain vacant unoccupied due to lack of demand, it should be made compulsory to submit applications for such types where there is surplus accommodation, and consequently the employees entitled for such types would not be eligible to draw house rent allowance. Paragraph 12. In response to an application filed by the petitioner on 16/2/2011 under the RTI Act 2005, making inquiry about the vacant type 4 quarters, the respondents had mentioned that a few type 4 bungalows had remained vacant during the relevant period. Relying on the said reply of the respondents, the learned tribunal had recorded a finding that there was no type 4, there was one type 4 quarter lying vacant during the period claimed by the petitioner, and hence in view of the standing circular of the Railway Board, the petitioner cannot claim HRA from the period from 25/9/2007 to 13/7/2009. It is apparent from the materials on record that type 2 quarter vacated by the petitioner on 22/9/2007 was allotted to one Abdul Nasser and with effect from 25/9/2007, and that is the reason why the petitioner had claimed HRA with effect from 25/9/2007. However, since the petitioner was entitled to type 4 quarter, hence the standing Railway Board circular would obviously have to be applied, and with reference to vacancy position of type 4 quarters and not the type 2 ones. The stated case of petitioner is that there was no type 4 quarter fit for occupation by any person that was lying vacant at the relevant point of time, and therefore the respondent cannot deny him the HRA on such account. The pleadings of the petitioner as contained in paragraph 4.11 of the original application has not been specifically denied by the respondents. There can hardly be any doubt about the fact that a quarter which is unfit for occupation, even if remaining vacant, cannot be treated as a vacant quarter within the meaning of the relevant Railway Board circular so as to deny the benefit of HRA to the petitioner if he otherwise entitled to receive the same under the rules. Therefore, the entitlement of the petitioner to draw HRA for the period in question would depend on whether there was any type 4 quarter lying vacant which was fit for occupation by an officer. We have gone through the records produced by Dr. Gogoi, and we find that the concerned authority of NF Railway had certified on 13/7/2009 that the petitioner would be entitled to draw HRA with effect from 14/7/2009. There is, however, nothing in the record to indicate as to the basis on which the decision to pay HRA to the petitioner with effect from 14/7/2009 was taken by the authorities. The learned standing counsel for the NF Railways has not been able to draw the attention of this court to any material which throws light on the actual vacancy position of type 4 quarters during the relevant period of time. Not only that, Dr. Gogoi has also failed to give any convincing answer to our query as to how those 15 officers referred to in the departmental communication dated 23/3/2011 enjoying identical pay scale as the petitioner were permitted to draw HRA during 25/9/2007 to 14/7/2009 if type 4 quarters were in fact lying vacant during that period. Paragraph 16. The respondents have not cited any other ground for denying HRA to the petitioner during the period from 25/9/2007 to 13/7/2009. Having regard to the fact that the petitioner was has categorically pleaded in the way that no type 4 quarter fit for occupation by the officials was available during the relevant point of time. In the absence of any contrary material available on record, we are unable to persuade ourselves to accept the contention advanced by the departmental counsel that the reason for denying HRA to the petitioner from 25/9/2007 to 13/7/2009 is on account of availability of vacant type 4 quarters. Rather, we are of the considered opinion that the claim of the petition for HRA for the period from 25/9/2017 to 13/7/2009 had been rejected by the departmental authorities in an arbitrary manner without there being any valid basis for doing so. For the reasons stated herein above, we are of the unhesitant opinion that the learned tribunal was not correct in rejecting the application filed by the petitioner. Judgment dated so and so, passed by the learned central administrative tribunal is therefore set aside.
Now just tell us you are covered by which particular circular? The circular issued on 9/5/2000 or something else?
Lordship, upon reading page 61, seen that Lordship, the earlier circular, the validity of the earlier circular was till 31/3/2003.
Then
And
it was extended. The power was given to the general manager and the other authorities to consider to allow you HRA or not, right? Now just tell us.
if this paragraph 3, Lordship, was not at all required, Lordship, then it would not have been incorporated in this circular, Lordship. So, this was necessary, Lordship, that is the reason why this was.
Okay, let us hear the railways.
Lordship.
Heard you enough.
Well, the case is very simple.
Yeah, understood. That,
Only thing is that, I guess, what is your office query?
no, what is the fact that he is entitled, the claim of the petitioner. It's to go ahead.
The basic case, in a nutshell, let me argue, a railway employee.
No, we want to clarify, we want that clarification from you. Is that petitioner was earlier occupying type 2 quarters. On his promotion, he is entitled for type 4 bungalows. He was given that benefit from July 2009.
94.
2009. And from 25th of September 2007, his claim is from 25th of September 2007, he was entitled for HRA. It was not considered, but without his application, it was given to him from July 2009.
Yes.
Now, reading that process, he has given a list of 15 such persons who also were provided with outstanding rights without their applications. Number one. Now, at the same time, he has also filed RTI to know that from 25th of September 2007, availability of the quarters
4 quarters.
has given 4 quarters. The thing is this, the claim for HRA by the petitioner, first of all, it will tell us whether it will be under the circular of 9th of May 2003 or the earlier circular at least.
There is no difference between the earlier circular and this circular.
There is a difference. Only difference is by this particular circular where the power was earlier granted delegated to the manager and the heads of the organization has been extended up to 31st of March 2010.
That's
The 11th period is between this. So he is basically covered by this circular of 9th of May 2003. In the 9th of May 2003, there is an added clause.
no guarantee.
Come to clause 3,
Page 66.
61. For our understanding, kindly read it again.
One thing is that vacancy and lack of demand. These are on the same footings.
Not at all. You read that for clause 3.
Clause 3. In case of any in case at any point of time it transpires. The word transpire is important. It transpires that some accommodation is likely to remain vacant, unoccupied. Vacant and unoccupied are on the same footings, due to lack of demand. Railway have a number of quarter vacant, but nobody has made an application for allotment of those.
Then next part.
Oh yeah, let me put clear. Nobody has made an application for allotment of that quarter. Then what would happen? It should be made compulsory to submit application for such type where there is a surplus accommodation. Where there is a surplus accommodation, one should make an application. And consequently, the employee is entitled to, for such types of would not be eligible to any house rent allowance. Because before going to that, let me know just 1 minute time I would like to do. Let us understand the case in that way. A railway employee is compulsorily entitled to quarter. One thing should be bear in mind. And if no quarter could be allotted to a railway employee, then and only then he is entitled to house rent. All railway employees are entitled to have a quarter. And if the quarter could not be allotted, then and only then he is entitled to house rent allowance. It is not that one must apply, etc., etc., etc.
Please. Now here
he was allotted with a quarter in the year 1994.
we are not on the past. From the date he surrendered the type 2 quarter, he was entitled for bungalow, that is type 4 quarters. If you read page 61, that circular of 9th of May.
Yes, it is me.
Clause 3.
Now, one thing.
Yes.
I have a quarter. I have surrendered that quarter because of the fact that I have constructed a house. I went to my residential house.
While he was occupying type 2 quarter, was he entitled for type 4 bungalows or not?
No. Yes, he was available.
So
his own option.
Basically, if he was having, whether at any point of time, as soon as his promotion, he was entitled for type 4 bungalows.
Type 4 quarters are available.
That will come later. When did you transfer that type 4 quarters are available? If it was type 4 quarters are available, why did not you allot it to others? As per the RTI applications, those were pending at that point of time.
No, allotment type 4 quarters.
Plus, there's through RTI, there is a list of certain numbers of applicants as on September 2009, 25th of September 2009.
Yes.
And why those quarters are not allotted to them? There are applicants, forget the petition. Why you have not allotted to them? You have allotted to them at a later stage.
Four quarters are vacant.
You see, the RTI reply is very clear if you come to read at page 91.
Page
91. Then please come to page 93. Right? These are the applicants. Page number 93, 34 applicants.
Number 93.
That's the annexer 1 of yours. Reply, RTI reply. And page 95, out of those 34s. Page 95.
Yes.
there are quarters were allotted to 22. Applications of 34 are pending and quarters were allotted to 22.
When?
Right?
Hmm.
These are your reply.
Oh.
Now, the petitioners contended that initially, if you come to page number, the petition at page,
No, application dated, last application dated is 24/9/2007.
Because the next page 95. you'll see that
2009, last application is dated 2024/9/2007. And petitioners
Last
are,
application is of 25th of 9, just before that you will see.
oh yes, 25th, well, not
25th
20,
was
29, 27, 2007. That is the last application.
Information that was sought for was applications pending as on 25/09/2007.
Hmm.
Now, the annexure 2 is the allotment.
And next, sir, page
Page
95.
95.
Hmm.
Officers from annexure who had been allotted type 4 transit accommodation is under. Of course, date of allotments are not there.
Hmm.
Out of 30.
Yes, data allotments are there.
No.
Date of applications,
Allotments are not there,
Oh, yes, yes.
right?
Hmm.
So out of those 34, because the query was up to 25th of September 2007, how many applications were pending?
Yes.
And out of those 34, only 22 were allotted.
No, I'm sorry to interrupt your worship, Lord. The quarters are of different grade, grade 1, grade 2, grade
No, no,
3,
just
grade
see
4.
Heading, page 95.
90?
That's your reply, annexure 2.
Officers from Annexure 1 who had been allotted type 4 transit accommodation is as under.
So names are there and date of applications are there,
Yes.
right?
Hmm.
Now, when did you transpire during this period? Now, there is another issue. Please come to page number 44. The read petition.
Page number?
44. This is a list of 15 such employees who are entitled
Yes,
for
yes.
type 4 bungalows or type 4 quarters, whatever you say.
No.
No, that is the confusion that has created.
That's right. That is the reason the order has been reviewed.
Yes, yes.
Now, according to the petitioners, these 15 persons has been provided with
House and allowance.
though without their applications or whatever, they are similarly situated that as the petitioner, and they have been provided with.
Yes, this is the simple case.
Now, that's the case of the petitioner.
Yes.
Now, coming back to page 61.
Yes. In case any point of time.
At any point of time, that means during that period, say from 25th of September 2007 to July 2009.
Some accommodation is likely to.
It transpires by whom? By the railway authority.
Yes, yes.
Some accommodation is likely to remain vacant.
Oh, yes.
That there are certain vacancies likely to remain, certain quarters unoccupied or vacant due to lack of demand. This particular clause, due to lack of demand,
That is very much clear, Lord.
it has to be first decided by the railways that due to lack of demand, because at any point of time you can transfer, that due to lack of demand, these quarters are lying vacant or remain unoccupied. Number one. Then, that is the first part. It should be made compulsory. That means it should be made compulsory means that the general managers or the head of the organizations must notify, because it should be made compulsory. Unless you inform the applicants or whoever is entitled,
So according to your lordship,
Yes.
that it is the duty of the railway authority to notify that you see there are number, these numbers of vacant quarter are there. If
No.
anybody is interested, please apply.
Not
If
that,
it is
not
the,
that.
probably it is the interpretation of your
No, no,
lordship
no,
on
not-
this clause.
Not at all.
And
Yeah,
as there no notification was made, so
That is not the conclusion of the court at this stage. First of all, there has to be a finding by the railway that there are certain accommodations are remaining vacant and unoccupied due to lack of demand. That has to come from you. No applicant will be able to know
yes.
that there was lack of demand. Nobody will know. They may at least apply or may not apply. So that vacancy is lying or the unoccupied, the quarters are unoccupied due to lack of demand. That, where is that your decision first? In that circumstances, as per this May 2003 notifications, any such persons without any applications will not be eligible for house rent allowances. But when did you transfer?
Milord, you have to
There is a lack of
argue,
demand.
piecemeal argument will not be possible,
That
Milord.
is true, because you just see what you have done in your reply. You cannot now change the case.
No, I am not changing my
Now
case.
please come to page number 54. Your reply before the tribunal.
Yes, yes, that is it.
Read paragraph 4 totally.
Yes, yes.
Kindly read paragraph 4.
Yeah, that with regard to the statement made in para 4.4 of the original application, the answering respondent, while denying the contentions made therein, begs to state that the provisions oblique guidelines relating to the grant of house rent allowance is subject to the review of the railway board from time to time. All right. The railway board circular number such and such dated 1988, 7/6/1988. That is very much important. First circular. Para 3 provides as follows. That is page 31. In case of a surrender of accommodation, the house rent allowance, if otherwise admissible, will be payable from the date it is certified by the accommodation controlling authority that no accommodation in the entitled class is available. That is, let us suppose for something. Now, what happened here, Lord? He was allotted the house rent allowance during his period of service. And that allotment was granted to him from what date? 14/7/2009.
We are not on there.
Because of the fact on that day, no accommodation was available.
We are only in between that period from 25th of September 2007 to July 14, 2009.
Okay. Let it be clear from subsequent reading. The para 5 of the said circular confers power upon the general manager and other head of the organization to sanction for eligibility of house rent allowance in types of cases mentioned therein. The para 6 of the circular further provides that even if area issue of order, even if after issue of orders granting HRA, it transpires that some accommodation, even if after issue of orders of granting HRA, it transpires that some accommodation is likely to remain vacant, unoccupied due to lack of demand, the order should be reviewed and it should be made compulsory to submit the application for such type where there is surplus accommodation and consequently the employees entitled for such type would not be eligible to draw house rent allowance. The Railway Board issued the circular dated 9/5/2003 regulating the admissibility of the house rent allowance in the event of non-acceptance or surrender of railway residential accommodation. Para 3, having significance in the issue involved herein, is quoted below for ready reference. In case any point of time, it transpires that some accommodation is not likely to remain vacant unoccupied due to lack of demand, it should be made compulsory to submit application for such type where there is surplus accommodation, and consequently the employees are entitled for such type would not be eligible for house rent allowances. Okay. Meaning thereby, if the officer is entitled for a type 4 bungalow by virtue of his designation /grade, pay, and there are several type 4 bungalows lying vacant, unoccupied due to lack of demand. In such eventuality, the officer, as per the mandate of the circular, must submit application for allotment of the vacant type 4 bungalows. If the officers concerned do not submit such application, he would not be eligible for HR. Now, my lord, sorry.
You are absolutely on that point. See, in such an eventuality, the officer, as per the mandate of the circular, must submit application for allotment of vacant type 4 bungalows. Come to the
page 61. Just a minute, may I interrupt for a second?
Sure.
But here the case is a special one, because once I availed a quarter, thereafter I have constructed my own residential house and I went there. Now, despite my going there, whether I am entitled to house rent allowance or not. Yes, according to the railway authority, yes, you are entitled to house rent allowance if there is no allocable surplus quarter for allotment. Now, at the relevant point of time, there was allocable surplus quarter for allotment. But this allocable surplus adjusted on 25/9/2014. 13/9/2009. And from that day, straightway we offered him without any application. Meaning thereby, that till 13/9/2017, there was some vacant quarter. And when these vacant quarters were exhausted, then and only then you are entitled. One thing is that, Lord, a railway employee is entitled to his quarter, even if he has his own residential house. If the no quarter could be allotted to him due to lack of available vacant quarter, then and only then he is entitled to have his housing. Now, our case is that vacant quarter was there. Probably they want to project this case at this stage. We don't know whether there were vacant quarter or not. It is incumbent on the railway authority to notify that you see there are some vacant quarter, you should make an application. Probably that is their case now.
Of course not. Just see, come to page number 34. Come to page number 34.
Yes. Sorry, 34.
The writ petition.
Yes. Page
This
number.
is a letter of 27th September 2007. He is asking for HRA. Then
It is 27/7/2007.
2007.
27/9.
Is it 9? I don't think so. Is it 9?
Yes, probably 27/9. Yes.
7. It is very clearly written on the left side.
No, 20, the, on
No.
typed 27 September.
27 September, type copy.
It's a 27th of September only. Then come to next page.
Grant of house and allowance, we allowed him 27.
We have given him from 14th of July 2009.
Yes,
right?
yes, yes.
Then he wrote another letter on 17th of July 2009.
36.
Page 36.
Then another letter on 37. Another letter on 38. This continuously doing. There was no reply,
Yes,
right? Ultimately,
yes.
filed RTI to know the reason.
Hmm.
Now, that is the, if you read clause 3 at page 61, or as you have said in your paragraph 4 of the written statement, it is very clear. You should have replied back.
Page 61.
Page 61 clause 3, which you have also quoted at your paragraph 4
Hmm.
of your written statement at page 54 and 55.
Hmm.
You should have replied him that we have transpired, that these are the vacancies available, these are unoccupied due to lack of demand, and since you have not applied, you are not entitled for HRA during that period. You have not replied. That particular observation in the notification, because you have that power, any point of time it transpires, you have that power.
Hmm.
You have not that there was lack of demand. That which you have not done. And the reason you have not done, you have not informed him during this period till he filed his application before the tribunal. You have not informed him at any point of time that he is not entitled for the house rent allowance because it has
No,
come to
it
our
is,
notice.
no,
The clauses is such in case at any point of
no,
time.
Lord, if we go through his entire petition, I will argue this matter. If we go with his entire petition, what I have understood, it is not his case that the quarters are not available. It is only case before your lordships as
That he
well
has
as
built
with
a
that,
house, he has
that
shifted to
these quarters are not,
That's not the thing.
no, this
Mr.
is not suitable for accommodation.
Gupta, we are not, the parties are.
Their case.
His
No,
case is
if
very
this-
clear, he has shifted to his own house.
Hmm?
He has shifted to his own
No,
house.
no, no,
so
no. He,
Your first
one thing, even if I am a railway employee and I am residing in my own house, then also, Lord, I can entitle to,
House rent allowance, if the bungalows are not available or quarters are not available.
yes. That is his. Now, his case, now this case has been projected by your lordships as well as he, is that as if it is his case before the tribunal, as well as before this court, is that, yes, there were quarters, but these quarters were not suitable for accommodation. That is his case.
That is his case.
Yes. And your lordship has promptly responded, yes, if it is your case, whether you have applied for the accommodation or not.
Rightly. Definitely.
Ah.
You have seen-
But he says, no, I have not applied. So if we go, let us think is equitably,
Hmm.
not very technical.
Rightly.
Equitable thing is that it is his case that the quarter which are available are not suitable for accommodation. And that is why, Lord, I did not know that.
See, it is, you have placed before the tribunal, then since he has not applied for the water during that period, he is not entitled. Your case before the tribunal is, he has not applied for the water, so he is not entitled.
He only applied for the house rent allowance
He has applied for the house rent allowance.
because of the fact that he is residing in his own quarter, own house.
Own house. That is his application.
Uh-huh.
Application that now you have read in September 27 that he has filed. So your rejection is that he has not filed any application. Because in the written finding by the tribunal as well as your written statement is very clear that during this period, he has not filed any application for allotment of any such bungalow or any such quarter. Right? That is why rejected.
No, no, yes, Let, Miller,
That-
I shall go through the,
that-
one day time I will take a look.
That good because the,
But if I can project my case before your lordship, that he knows better that there are some vacant quarter. But this vacant quarter, he did not avail this vacant quarter because those are not suitable for accommodation. Then probably his case is not a good case.
kind
That
of,
should be.
you can establish something else good, but entire limit of the case is that he did not apply, that's why he's not entitled.
No.
If you read your written statement before the tribunal,
He has to apply.
it's very clear that since he has not applied for, he is not
No,
entitled.
actually, he has applied for house rent accommodation.
He never.
He has
applied.
never applied for any quarter.
Absolutely correct.
So if he had never applied for any quarter, then we could not allot him any quarter. Because despite the fact that there were some available quarter, 4 number of quarters were available. Now his case is that in a similarly circumstances cases, some persons were allotted.
That will be something else. We are not on that.
Yes.
We are not on that. As you have said that you have negative equality doesn't arise. We are not on that. But.
Now, let us come to the page
Page
31. Page 31 first.
That is why first clarify
Hmm.
whether his house rent allowance, this thing will be entitled under this particular notification of 9th of May 2003 or that of the page 31.
7/6/2018.
June 1988.
So is there any difference between these two
Yes,
circulars?
yes, there is a difference. Just see. There is, because there is no mention about that particular, while issuing that 9/5
Yes.
2003, read page 61.
Yes. In page 31, it will also come to paragraph 6.
No, please. First of all, you come to page number 61,
No, first of all, let's come to page number 31,
please.
paragraph 6. In case after issue of the orders, it transpired that some accommodation is likely to remain vacant. Same thing.
Same thing.
Unoccupied due to lack of demand. The order should be reviewed and it should be made compulsory to submit application for such types where there is surplus accommodation and consequently employees entitled for such types would not be eligible for draw house rent allowance. Yeah, add verbatim which is incorporated at page 62.
Now, please come.
Yes, please, let us come finish it. Page 62, 61. Same thing. It is not that. In case,
Read the reference.
no,
Read the.
let us first come to that paragraph 3.
Why
In case it transpires, every words are identical. In case at any point of time it transpires that some accommodation is likely to remain vacant, unoccupied due to lack of demand, it should be made compulsory to submit application for such type where there is surplus accommodation and consequently the employee is entitled for such type would not be eligible to draw house rent allowance as it is.
Now, in that particular circular, kindly read the reference.
As it is, below.
Kindly read the reference.
Oh, sorry.
Page 61.
Yes.
61.
A reference with all no letter. Not the.
It doesn't consist of any letter of 7/6/1988.
Or it is from other income.
So
in context.
probably this 7/6/1988 letter was, the circular is no longer under continuation.
No.
That in the.
Because there is no reference, just see.
No, it was for
For some other purpose.
that purpose, below.
No, Lordship. There is another circular, page 73, Lordship.
Twenty-three,
73. This
Page
is of
73.
23/1/1999. It's on the same issue, Lordship. So these are being reviewed time and again by the.
But it has not been done away with in the 1988 circular.
Yes, even in 1988 circular, page 73. So,
No, in the circular of page 61, there is no mention about the.
no, Miller, I have to inquire, I have to take instruction whether this circular of 61, 88 is still in force or not.
Because
Seven-
probably 9/5/2003,
Yes,
is the,
Page 61.
that is the circular
Hmm.
where there is no mention about 7688 circular.
No, the 7688 circular is not mentioned, but the content of 7387 has been incorporated.
That has been incorporated again. They are not saying anything in this regard. That is the reason. Maybe at certain point of time, this particular circular 7688 may not have been continued, discontinued. We do not know.
No, let me have some instruction whether this is being discontinued or not.
Right.
And even if it is
Even if it is
discontinued, then also that he has no case.
No, even if it is discontinued, then what will happen?
Yes.
Then that application, those who did not file any application, they are also entitled to, for HRA, will not be there. That is the only circular where there is a mention that without filing any application,
For allotment of quarter.
without filing any application, a person is entitled for HRA. Because in the other circulars, it is not the case. In that particular circular of 76/1988, there is specific provision for allowance of HRA without filing any application. Of course, in that particular circular of 76/1988, there is a clause 6
Yes.
where similar to that of the page 61 of 2003. Why it was reiterated? Because you see in the reference, that particular clause, it has to be reiterated that it means that 76/1988 circular has been discontinued. Otherwise, that fact would have been there that even the employees of the railway, without filing any application, will be entitled for HRA.
Let me
Clarify it.
All right.
There would have been no reason for revisiting the same. Had been
No,
mentioned.
no, it
76.
was delegation of power. This circular was issued
Exactly.
with regard to the delegation of power.
Because initially
It is not with regard to the allotment of house and allowance, etc. It is only with regard to the delegation of it for some other context.
Administration in the event of non-acceptance on silent, that is just.
2 and 3 clause are there. That's why find out the 7688 circular is still valid or not.
Yes, all right.
Or at that point in time, when the case of the petitioner was rejected, whether it was valid or not. That's all.
Or whether it was superseded or not.
And if it is discontinued or superseded by subsequent circulars, from when? From which date?
I don't think that is, but anyway,
I think prior to this, later than this, there is another circular,
99,
15th of March 1996.
page
Same page 73.
73,
That may be an issue, we do not know.
15/3/96.
That circular hasn't been annexed by either of the parties.
So let me collect those circulars first.
Because after 1996, this 73 circular, that page 73, 99 circular came into force.
Now, after 96, 99 circular.
That is, you have annexed.
Yeah.
And after 99 circular, it is this page
To
61.
2003.
2003. No, in between, there are some other circulars. 93, then 96, 99, page 61.
Yes, page 61 is 88. No, 2003.
There are certain more circulars. One is of 14th of February 1996. Another is of 12th of July 1999. And then 16th of October 2002.
All right, I shall collect it.
When? Harding part. This week itself, we'll have it, hear it next week. The circulars are available with the railway. Right? Or Mr. MP Sharma, counsel appearing for the petition. A. Das Gupta, learned senior counsel, assisted by Mr. S. Sopravutu, learned counsel for the railways. List on.
Some time will be allowed because I have to make some correspondence with them. And it may so happen by Junior may go to
We will
the
have it on 12th of October.
12th of October. That will be better.
Would be helpful if my senior or my friend also gives me a copy of those circulars.
Now, if I get, definitely I will do. Why not?
You are a railway employee, it is easier for you to get it.
Maybe I should be retired now.
Even then,
Register copy of the Kabilnama was called for.
We sent it, my lord. We sent it on 31/7/23. Let it come after 2 weeks, my lord. Probably we will get it. As per order, 27/7/23.
on Kabilnama has been received.
Yes.
Go through it and tell us. This was received by the office.
Kabilnama is in record now.
No, I think it's not. Because Ms. Verma was provided with photocopy of the writ petition and the Kabilnama.
Yes, the Kabilnama is there, my lord. We have received the Kabilnama.
The
But
office
the-
note reflects.
Medis register was probably called. A photocopy of the writ petition and copy of the order is also provided to him.
Go through that this. Like X. But it was there itself on 31/8 itself. I don't know why.
May I go?
Okay. That Kabilnama was available. Just go through it, but records are not there. Last two pages.
My lord, the original marriage register was
That hasn't come, but just find
that
out.
has not come. Kabilnama is available.
The register was sought for.
Yes, register, the original marriage register pertaining to Kabilnama issued by the, that I will get the mother register. Kabilnama I have not. I got
You
it.
have.
Yes. Only the register of the Kabilnama.
Why this was called for 7399 2015.
7399/2015.
Then the reason.
Writ petition.
Yes.
7399.
7399 most probably res judicata was decided on that case. You know, so res judicata was decided on this case, on that case 73. Because here earlier some cases were there where they were two references were made. First, they were declared as the citizen of India. Thereafter, another reference was made where they were being declared as foreigner. So, question of res judicata was there.
733.
This matter relates to settlement of ferry service by Zilla Parishad. Just give us the record, let us see. Why we have been called?
733.
It might have been wrongly called for, or maybe the number is wrong. Seven three three nine. 7399. Seems better. 'My order dated 13/06/2017. The court called for the record of 7399 7339 7239 of 2015. Must Amina Khatun versus Union of India and 3 others. Disposed of on 17/05/2018. The registry wrongly forwarded the records of 7399/2015. Disposed of on 20/04/2016. That relates to settlement of Kadam KDUH, Kadam Sunapur, Baking Undi, Parakat by the Chief Executive Officer, Borpeta Zilla Parishad. Not connected to this. Next, registries are accordingly. Forward the records of CWPC number 7339. Dispose of on such and such. Return the records of application number 7399 to the record room. Mr. J. Bryan, standing counsel, Home Department. For some time to place the original marriage register in terms of the order dated 27/07/2023, directed by the court. Original register pertaining to the coding number issued by the Muslim Marriage and Divorce Register Samad Subdivision, District Sonipur, Assam. So, fine, man.
Any ditch, Malad?
Diversity.
Clerk,
You are talking about?
yes. Okay.
Seats. Pursuant to the prayer of the petitioner, the court accordingly allowed her, pursuant to her prayer, the court by order 25/07/2023 allowed the petitioner to file an affidavit bringing record of bringing filing annexing certain certificates Gangura. Petitioner certain certificates issued by the Gangura by way of definition. Accordingly, as June number 12 for 2 weeks. Office note dated 8/2023 reflects that affidavit has been filed by the petitioner. So our prayer was granted by the court on 25/07/2023. The petitioner do name of 3 councils have been reflected in the cause list. List of Mr. Define the standing council. List of current showing.
Please, your Lordship. Lordship, this is an appeal by, this writ petition is filed by Union of India, Lordship, against order dated 3/9/21 by the Honorable Central Administrative Tribunal, Lordship, whereby they allowed the original application filed by the respondent, Lordship, and set aside the memorandum of charge dated 21/4/17 and letters dated 14 to 20, which is issued by the inquiry officer issuing notice for preliminary inquiry hearing, Lordship.
Just a minute. Can you tell us that meter, the which pins is it? One to 188.
40 charge memo is from,
Page 72.
yes, Lordship.
Another letter mentioned it that Sir A3.
Yes, Lordship. Page 80.
80.
Yes, Lordship.
Where is the order of the tribunal?
Lordship, any page number 330, starts from page 335, Lordship.
Yes, how will you work on the findings of the Honorable Apex Court incorporated in this?
Lordship,
How will you overcome the decisions of the Honorable Apex Court incorporated in this order while the tribunal considered all those judgments?
Lordship, here,
Apparently, there was a delay.
Lordship.
And what about the other issues that the matter is pending before the principal judge and the Bombay High Court? This, there are delay in initiation of the department.
Lordship, here, although some delay is there, Lordship, but it, in my humble opinion, Lordship, it cannot be said to be a inordinate delay, Lordship. There are some ground why the delay was.
The tribunal, while after considering the judgment of the Honorable Apex Court, apparently found that it was something case of the appellate hearing, or the petitioner hearing, that we were not aware of the fact that incident did not take place earlier. For the first time, you have come to know how to sort this out.
Lordship, our stand is that we are not aware about that till 2000. We came to know about the 2013 CBI acts to initiate disciplinary proceeding, Lordship. And in the year 2017, memorandum of charge was issued. Lordship, here, Lordship would find that the respondent have taken more than 6 months time to submit his written statement, Lordship.
How is it?
And these all things.
How you have explained the delay? CBI have asked you in 2012.
2013 CBI acts to initiate disciplinary proceeding. We have issued the memorandum of charge on 2017, Lordship.
Now let us see.
Now, Lordship, after 2000.
Let us see your statement. Where is your written statement?
My lord, may I submit one aspect in the meantime? The basis of the charge sheet in the departmental proceeding is the CBI inquiry. That CBI inquiry was put to challenge before the Honorable Bombay High Court, and the Honorable High Court has quashed that proceeding. That is the status as on date. I had filed an additional affidavit bringing that judgment of the Honorable Bombay High Court on the record.
Basically, as you know, this criminal matter as well as this disciplinary proceeding are two different issues. They can always prosecute disciplinary
But
proceeding,
if,
even
yes.
if it is the criminal charges are set aside, right? So
But here I would like to submit one aspect, my lord. If I take your lordship to the charges, then your lordship will find
Charges we are not.
it is exactly same.
Maybe.
It-
But this is a two different proceeding, as you know.
yes,
Our High Court division bench have
Yes, yes.
verified that issues.
yes,
Even in the same set of charges, there is a criminal proceeding and there is a disciplinary proceeding. Even if in the criminal proceeding, the person is acquitted or the charge is set aside, but disciplinary proceeding. may
can
be-
still, yes, can still go.
So that issue will not touch at this point because it's already decided. But let us see what is the stand of the respondents.
In the written
Yeah,
statement, yes.
in the written statement.
Yes.
Written statement, Lordship, it starts from page 190, Lordship. Page 192 may kindly be taken up, Lordship. Uh, Yep. It is pertinent to mention here that a careful perusal of the representation would show that the applicant was reluctant to go on departmental proceeding pending criminal trial, and that he took more than 6 months to send a statement of defense against the charge sheet. The applicant was reluctant to go on with the departmental inquiry pending criminal trial in respect of the same incident is clearly a stop from contending before this honorable tribunal that the charge sheet is in respect of an incident of 2012 and that the charge sheet is continuing to pen for a very long period and hence should be quashed on the ground of delay. The allegation of delay by the applicant therefore cannot be an allegation which can lie in his mouth. It is further respectfully submitted that the Honorable Supreme Court repeatedly contended in a catena of ruling that whenever the integrity is in doubt, a departmental proceeding should not be normally quashed on the ground of delay as long as the applicant is not able to show that the delay has caused any prejudice to him. In the present case, since the criminal case was already lodged in 2014, it cannot be contended by the applicant that the pendency of the charge sheet which was issued to him as late as on 21/4/2017 and in respect whereof he did not give his statement of defense for a period of more than 6 months should be quashed by this honorable tribunal on the ground of gross delay. In this regard,
Whether the applicant. Let us see the charge, then we will come to
Logic.
that.
page
Charge memo starts at page
page
71,
70.
right?
Yes, Lord.
Now, at page 71, the applicant was directed to submit his reply within 10 days from the receipt of the same.
Yes, Lordship.
Whether thereafter he took time from you to file his reply.
Yes. He had submitted his reply.
If it has been filed after 6 months, why have you accepted it? Was there any reason that you have already considered to the fact that you have given him time to file his reply? Why have you accepted his reply after 10 days? Since he did not reply within 10 days, why
Lordship.
did not to proceed?
Without accepting that, Lordship, in that case, Lordship, again, natural justice violation will come, Lordship, and
Why have you extended the time?
oh, we have not exceeded, but he had not submitted, but after whenever he had submitted, we accepted that.
Then if you have, then where is in that, how are you able to take that stand? If he hasn't filed his reply within 10 days,
Lordship.
you could have initiated the proceeding. Why have you waited for 6 months?
He had submitted his reply on 29/9/17
I
and
understood.
yes, Lordship.
Why you have accepted his reply? For an employer, it is always easy to blame the employee, right? In this recent time, you have accepted it. Why you have accepted? You could have initiated the departmental proceeding
Without
without
that,
his reply because he did not file any application for extension of time,
no, he had not
right?
filed.
The 10
Yes,
days period was already over long back. So why you have waited? Okay, then next issue, let us see what is the next time.
According to Learned Tribunal Lordship, there are more than 53 officials, but others, uh, the proceeding was against the petitioner only, Lordship. Here, my submission is that there was no such evidence against those persons, Lordship. But here, there is a direct evidence against the respondent that he had availed benefit from the Sankalpa Consumer Private Limited, Lordship, for hiring of vehicle and for booking railway tickets, etc. And regarding the delay, Lordship, one thing I must submit, Lordship, that although the memorandum of charge was issued in the year 2017, Lordship, and we have appointed the IO. After 2 years of appointing the IO, Lordship, only on issuance of that date for fixing final preliminary hearing, Lordship, he had filed this original application, Lordship.
Where is the letter of the CBI?
Lordship, page 90 is the letter whereby we have written, which we have written to the CBI Lordship, where they ask us in reference to their letter dated 23rd May 2030.
What was that later?
This is a letter where we have stated that this Sankalpa Consumer Product Private Limited is not a
What was the letter of the CBI?
23rd May 2013. Nine. That letter is perhaps not a part of the pleading, Lordship.
So it's just like this. On 23rd of May 2013, CBI wrote to the CSD for certain information.
Yes, Lordship.
With regard to that, the CSD on 5th of June 2013
Yes.
submitted its reply.
Yes.
Now, thereafter, on 21/4/2017,
Yes. Memorandum of charge.
such memorandum was issued. No, 31, which was received by the petitioner on 31st of May,
Yes.
right?
Yes, Lordship.
Then thereafter, he on 7th of June
Yes.
2017 wrote to the authorities enabling him to inspect certain documents because
Yes.
some documents are not available.
Yes.
That was not replied. Then another letter was submitted in August as per the reference. But we do not know, we have not seen that letter. That you will find it at page 94.
Yes, Lordship.
First, his
This
first
is
letter
his
was
reply.
7/6/2017. Second, which was not communicated. Thereafter, another communication was made on 14th of August 2017. Thereafter, he filed his reply on 29th or 20th of September
Yes.
2017.
On 12 to 18, we have appointed the inquiry officer and presenting officer.
Then there was another letter of
27 November, he had his
1st of 11/2017. Page number 102.
Yes. 102.
Either to accept or to reject the charges, right?
Yes.
So further 10 days time was granted. It
Then
was
this-
communicated to him on 9th of November 2017.
Yes.
Then he replied on 27th of
27th of November,
November 2017.
whereby his prayer is that till may kindly be stayed till final decision of the criminal case.
These judgments were placed by the petitioner himself in his reply or subsequently annexed?
This is filed before the CAT, Lordship. This is the copy of the application that is filed in the CAT. Both sides have. Both sides have annexed certain judgments, Lordship, for the CAT.
The presenting officer
12 to 18, Lordship, page number
136.
136. Presenting officer and inquiry officer and presenting officer were appointed.
135 and 136.
And this OA was filed on in the year 2020, 75 of 2020. After 14 to 20, when inquiry officer fixed 3/3/20 for preliminary hearing.
Challenge that particular.
Yes, Lordship. Both memorandum of charge and the notice dated 3/3/20, 14 to 20.
Just a minute. So basically, you have not explained why from 2013 to 2017 there is a delay.
Lordship, page 194, our reply, Lordship, paragraph 2.
That's what we have read.
Yes, Lordship.
You have said that it is the petitioner delayed his reply for 6 months. And then they did not inform you the progress
Yes, Lordship.
about the CBI court. Is the ground of delay.
Those are the main grounds of delay.
It's actionable in law.
But Lordship, here allegation is serious, Lordship, in that the judgments of
That's
Supreme
true.
Court is that.
Allegations are serious. Allegation needs to be proved. That's why disciplinary proceeding. We're not in the criminal side, right? But thing is this, you have to explain. Is this explanation is sufficient?
Lordship,
That the petitioner filed his reply, delay in filing his reply 6 months, but the delay has been again accepted. Now we cannot reflect that. You have accepted his supposed reply. That reply you have accepted, then you have again asked, you have given him 8 days time. Either to say yes or no.
Lordship,
with regard to the charges, right?
Lordship, some delay is there, Lordship, but whether it can be in the call as an inordinate delay, Lordship, considering those aspects also, Lordship, that a CBI case is there, Lordship, and judgments are also, we have NX, Lordship, which judgments are not considered by the Honorable Tribunal also.
Which are the judgments and such?
On the basis of those.
With regard to your submission, which are the judgments that you relied? And the judgment cited by the petitioner, why it will not be applicable for this case as differentiating? You relied,
From 308, Lordship,
no, I think so in your,
in our, yes, Lordship.
you have relied on page number 192. Union of India versus Ibrahim.
Lordship. The Padmanabhan versus Government of Andhra Pradesh, Ananta Kulkarni, those I have annexed here also, Lordship. Lordship. First case, Lordship, there is 312.
Mr. Doctor, ask your colleague to note down the judgments which you relied upon before the trial.
Yes.
Yes, Mr. Yes, the judgment that you have relied
Yes,
upon
Lordship.
against 312.
308 V Padmanabhan versus Government of Andhra Pradesh and others. Prior to that, 307 is also there, Lordship. 307, this Muhammad Ibrahim judgment. Paragraph is a small judgment, Lordship, paragraph 2. 307, paragraph 2.
How Padmanabhan case, Jamshi?
Padmanabhan case, Lordship, paragraph 13, Lordship, page 312. This case, however, stands on a different footing. There was no delay in the matter of initiation of the departmental proceeding. It was in different case. Lordship, next page. The appellant, however, filed the original application before tribunal in the year 1997. It was disposed of by the tribunal by a judgment and order dated 2/1/2002. The state immediately filed a writ petition before the High Court, which was disposed of by an order dated 23/11/2004. It is during the pendency of the matter before us, the appellant is said to have reached the age of superannuation. We therefore are of the view that delay alone in a case of this nature should not be held to be fatal in the matter of continuing the departmental proceeding, as the charges against the appellant are serious in nature and a large sum of money have to be recovered from the appellant. It is thus not expedient in the interest of justice that on the ground of delay alone the matter should be given a quietus. Then they had the Honorable Supreme Court referred certain judgments.
See how the difference is. Come to para 11, the other is 311.
Yes, Lordship. Mr. So-and-so, however, would urge that having regard to the fact that the departmental proceedings were initiated in the year 92-93, this court should not direct continuation of the departmental proceeding any further. Strong reliance in this behalf has been placed on so-and-so. We have noticed here before that continuation of the departmental proceeding is not illegal. The pension could raise a legal friction in terms whereof the departmental proceeding would be deemed to have continued. The tribunal has passed an order in favor of the appellant on technical ground. The High Court, therefore, in our opinion, cannot be said to have committed any illegality in passing the impugned judgment. It may be true that in so-and-so the court relying on
Come to 312 on the right side.
Yes,
That is a case where the paragraph 16 of the Mani Singh case has been considered, right?
yes, yes.
Now, the finding of the court is that in that case, what? Before 30,
Yes.
then they did that.
In that case, the disciplinary proceeding were initiated 5 years after the appellant therein had handed over charge. It was opined that he was not having possession of any documents. 7 years' time was taken to complete the inquiry. Appellate authority also took 5 years in disposing of the appeal. None of the authorities had taken into consideration as to whether the procedure laid down under the rule has been followed or not. It is in the aforementioned fact situation such a direction was issued.
That was a different case altogether, right? Here, in that particular matter, in Padmanabhan matter, the council court said, though it was started in 1990 to 1993, matter went ahead, and thereafter, these days, there should not be allowed to be continued. In that circumstances, the court, the Honorable Apex could have held that this will not be applicable because delay was not in the case of initiation of the departmental proceeding. Delay was after the disciplinary proceeding, right? So I don't think so that case, because the facts of that case differs. Here, the initiation of the departmental proceeding was delayed from the end of the employer. Can you tell us any such judgment wherein such delay has been considered?
Logic.
Any other judgment you rely upon?
Logic Satyendranath Pandey is there. Next has been here also, Lordship, page 327. But here also, Lordship, close the matter on about 16 years have elapsed since the date of commencement of disciplinary proceeding, more particularly when the appellant alone cannot be held responsible for this delay. So far as the merits are concerned, we regret to say that the High Court has not dealt with the submission of the appellant, that in spite of being given a number of opportunities, the first respondent has failed to avail of them. If the appellant allegations are true, then the appellant cannot be futile for not holding a regular inquiry. So the High Court has assumed, even without referring to Regulation 68, aforesaid that holding of an oral inquiry was obligatory. Indeed, one of the questions in the writ petition may be the interpretation. So on fact, the first respondent has his own person. In the circumstances, the writ petition could not have been allowed unless it was held that the appellant person of event is not true and that the first respondent person is true. So here the Union of here Deputy Registrar Cooperative Society is the appellant. The main ground is that allowed the appeal, but here also Lordship 16 years since the date of commencement of disciplinary proceeding. In between that, Lordship. The next case is Chamanlal, State of Punjab and others versus Chamanlal Goel, Lordship. Here, paragraph 5, page 329. May I read, Lordship? No action was taken against the respondent until 1992. He continued in service as usual. For the first time, he was called to the office of the Secretary to the Home Department on March 25, 92 for questioning, and thereafter the memo of charge was issued on July 9, 92. Respondent submitted his explanation on January 4, 93, denying the charge. After obtaining the comment of the Inspector General of Prison on his explanation, the government appointed an inquiry officer on July 20, 93. Soon thereafter, respondent approached the High Court on August 24, 93 by way of a writ petition seeking the quashing of the sergeant and orders appointing the inquiry officer. It appears that though the writ petition was entertained by the High Court, the inquiry was not stayed, with the result that it commenced in September 93 and proceeded apace. On July 26, 94, the evidence on behalf of the government was completed. Respondent was to adduce his defense evidence, if any. At this stage, writ petition was allowed, as a result of which the inquiry could not and did not proceed further. The High Court quashed the memo of charges on the following grounds. Then, Lordship, it went to the Supreme Court. Lordship, page 332, B, Lordship. Lordship, then 331, paragraph 10, Lordship. Now remains the question of delay. There is undoubtedly a delay of 5.5 years in serving the charge. The question is whether the said delay warranted the quashing of charges in this case. It is right to say that such disciplinary proceeding must be conducted soon after the irregularities are committed or soon after discovering the irregularities. They cannot be initiated after lapse of considerable time. It would not be fair to the delinquent officer. Such delay also makes the task of proving the charges difficult, and is thus not also in the interest of administration. Delay in initiation of proceeding is bound to give room for allegation of bias, malafide, and misuse of power. If the delay is too long and is unexplained, the court may well interfere and quash the charges. But how long a delay is too long always depends upon the fact of the given case. Moreover, such delay is likely to cause prejudice to the delinquent officer in defending himself. The inquiry has to be interdicted. Wherever such a plea is raised, the court has to weigh the factor appearing for and against the said plea and take a decision on the totality of circumstances. In other words, the court has to indulge in a process of balancing. Now let us see what are the factors in favor of the respondent. They are, then this is the facts of the case, Lordship. See, Lordship, if not in 92, his case for promotion was bound to come up for consideration. This 11. Now, what are factors against the respondent? That the respondent was never suspended, nor was he served with memo of charges, nor even with a questionnaire in the behalf till March 92, when he was questioned by the Secretary to the Home Department and charges served in July 92. He had suffered no discomfort or inconvenience on account of delay. The charges are very grave. Charges are not only what he was lax in discharge of his duties, but that he exceeded to every demand of theirs, and that in violation of the prison rule had allowed a number of terrorists to gather in one cell. So this is the fact, Lordship. Then the finding, Lordship, paragraph 13, page 333. Applying the balancing process, we are of the opinion that the quashing of charges and of the order appointing an inquiry officer was not warranted in the facts and circumstances of the case. It is more appropriate and in the interest of justice, as well as in the interest of administration, that the inquiry, which had proceeded to a large extent, be allowed to be completed. At the same time, it is directed that the respondent should be considered forthwith for promotion without reference to and without taking into consideration the charges and the pendency of the said inquiry. And if he is found fit for promotion, he should be promoted immediately. The promotion, this appeal is ultimately allowed, Lordship. Here, Madhya Pradesh versus Bani Singh judgment is also discussed on the question of delay. But in the judgment of the learned tribunal, Lordship, these judgments were not at all considered, Lordship. And the respondent approached after more than 2 years. He was also after appointment of the inquiry and presenting officer, he was also keeping silent, Lordship. And 12 February 2018 appointed the inquiry officer and presenting officer, and this appeal, sorry, this writ petition, this original application was filed only after getting the notice fixing preliminary hearing in the year 2020. So after about more than 2 years,
When it was served upon,
Lordship.
when it was served upon him, that notice of 2018.
12 to 18,
Preliminary inquiry,
yes.
when the particular notice was served upon him.
Preliminary inquiry notice was of 2020. Fixed 14 to 20 inquiry officer fixed 3/3/20, but
So,
appointed was in the year 2018.
But the inquiry officer for the first time initiated the proceeding only on.
14 to 20, he fixed 3/3/20 for preliminary hearing.
So that way, 4 years and 2 years. That's why this repetition, this tribunal prepared application in November 2020.
Yes, Lord.
The cases that you have cited, the offences were more grave. While reading the charge,
Lordship.
like whatever case you have seen, how the in the head of the jail, how he simply
Terrorist.
to a more softer place and more secure place. This is one personal conduct, right? Those things has been considered. That is why the Honorable Apex Court did not consider the punishing case, and now they will have considered the gravity of the offences. So as here, what are the charges?
Charges, Lordship.
Yes, the petitioner.
So he had availed services to the tune of rupees 1,98,829 from the Sankalpa Consumer Products Private Limited in the form of buying railway tickets and hiring of vehicles, Lordship. That is the main allegation, Lordship.
Now, in that case, can you show us that there was in the head of the CSD, right?
So-
Against the department particular.
So,
Does anything notified by you that before taking any such buying of railway tickets or getting some vehicles hired, it has to be only from the registered establishment? Is there any notification from your side?
Lordship, notification is
Any
not there,
circular,
Lordship.
Any circular or anything?
Notification is not there, but page 74 and 75, we have given a details of what is.
No, he has availed.
Yes,
Right?
yes.
Illegally. Only because it was not a registered establishment or something else.
So these payments of what he had availed is paid from the account number of Mr. Sankalpa Consumer Products Private Limited. But they are not the hiring agent or something like that, Lordship. They are the agent of some companies who is provided, who is supplied articles to the different canteens of army all over India, Lordship. So there is no direct connection with Sankalpa Consumer and army, this defense, Lordship. He is an agent. So like he was charged under conduct rule, Lordship, Central Civil Services conduct rule, rule 3.11.12 and 13.
Messrs Sankalp Consumer Products Private Limited
Yes,
was acting as an agent
yes,
under agreement with different companies for after sale service or sale of their products to CSD.
yes, Lordship. And now all these his tickets, etc., and his services were from the accounts of Sankalpa Consumer Products Private Limited. That is in page 75.
Now, page 74, just read Messrs Unique Travels.
Messrs Unique Travel Agency had raised bills for car hire charges in favor of so and so against to Mrs. Sankalpa Consumer Product Private Limited for rupees 52,768, against which 43,530 was paid and rupees 9,238 was outstanding to Messrs. Sankalpa Consumer Products Private Limited. Messrs. Sri Auto Travel had raised bills of rupees 89,763, out of which 73,384 was paid and rupees 16,379 was outstanding to so and so. Similarly, Arcade Road Thane Private Limited raised bill of rupees 6,027 and that is paid by Sankalpa Consumer. Vidhi Travels 33,779, that is also paid by Sankalpa Consumer. AB Travels bill and the VA Transport bill all were paid by Sankalpa Consumer Products Private Limited. Lodge.
So according to you, petitioner and the applicant has asked this Sankalp Consumer Products Private Limited to buy railway tickets and also allow them to hire vehicles. Right?
Yes.
How you are affected?
This Lordship, this is against me to this is defense Lordship. He has to maintain absolute integrity, discipline, devotion. Those things are there. And allegation is of conduct rule, Lordship, CCS conduct rules. That he had used this Sankalpa Consumer for his personal person. In that case, there is a possibility that maybe some low standard materials may have supplied because he is agent through some agencies. He is not a hiring agent, nor he is a this service holder of any flight tickets, etc. But then in that case, what is the relation between the petition respondent and that
This
is
Sankalp Consumer Products have hired this vehicle or purchased these railway tickets for the petitioner and his family?
Lordship?
For the petitioner or his
Yes,
family?
yes, they had a very many.
Now, just tell us one more issue. Whether these bills were footed by the Sankalp Consumer Products Private Limited or by somebody else?
From this memorandum of charges, it that they had raised, the agencies raised a bill to Sankalpa Consumer Private Limited, and Sankalpa Consumer Private Limited had paid them. Some are outstanding, maximum paid.
Now, just one more thing. Just come to the first paragraph.
Say 74 logic. Yes, the so and so while working as assistant general manager so and so at here Lordship, during the period from November 2008 to June 2012, abused his official position for himself and his family members in the form of transportation services by hired vehicles and railway ticket to the tune of so and so from Mr. Sankalpa Consumer Product Private Limited, Mumbai, with whom he had official dealings. Vehicles were hired and railway tickets were booked by so and so administrative executive of Sankalpa Consumer Private Limited as per instruction of Sri Milin Gavlika, director of Messrs. Sankalpa Consumer Products Private Limited, from Sri so and so from Sri Kishore Kumar Srivastav and his family members from different travel agencies. Sankalpa Consumer.
For or it should be for or for. It should be from or for.
It should be for.
It should be for.
For.
Now, This 1,98,859
Lordship.
rupees was paid by whom?
This Sankalpa paid to the agencies as as it is evident from serial number 1 to 6.
The applicant stated that there was no loss to the respondent authorities, as it was paid by, because we have seen the reply as well in the petition. There was no financial loss to the
But he had used his official, here it is, abuse his official position.
Just tell us one thing. Kindly read page 90. It has been written on behalf of the canteen stores department.
Yes, Lordship.
to the CBI,
CBI.
right?
Yes.
The reference.
Paragraph 2.
See the
Messrs.
references.
Reference number so and so, dated 5th June 2013.
Then down below, RC.
RC so and so Mumbai against the KK Srivastava, then AGM and CJM or DGM retired.
So issue relates to, that means 23rd May 2013, CBI wrote something to the CSD who know about the dealings between the petitioner and this Sankalp consumers.
Yes, Lordship.
Now, read.
Messrs. Sankalp Consumer Product Private Limited is not a registered firm for supply of products to CSD. We are therefore unable to clarify your query in para 2 of your letter under reference. As regards general instruction to R&D for delivery of purchase order, copies of following circulars are enclosed. 25th October 95 and dated 28th June 2012. Based on the authority letter issued by various suppliers, copies of purchase order official correspondences are handed over to the authorized representative of the company. Due to shifting of old records, we are unable to confirm about the firms which authorized Sri Ravi Jadhav and Sri Prashant Jadhav to collect the documents from CST.
Now, please come to page number. Page number 73. After that amount.
Page number 73.
73.
Sri Srivastava avail of the services of vehicles and railway ticket provided by Messrs. Sankalpa Consumer Products Private Limited for himself and the members of his family. Says Sri Srivastava was having official dealing with Sri Milin Binayak Gavlikar, director of so-and-so. By the aforesaid act on his part, Sri so-and-so, while performing his duty, did not maintain.
Just a minute. Messrs. Sankalp Consumer Products Private Limited for himself and the members of his family. The said Sri Srivastava was having official dealings with Sri Milan Vinayak Vilkar, director of Messrs. Now, what was that official dealings? Because the Mr. Srivastava was the AGM, right?
Yes.
And he was this, as per this letter of the
Page 90.
Page 90. He was not a dealer of any official. He was not a registered firm for supply of products of CSD. So how do you correlate this? If he is not a supplier, then in your search, the first thing article is that he is having a relation. How come?
He acted as an agent, Lordship. Here, this Sankalpa Consumer, he acted as an agent under agreement with different companies after sale services for sale of their products to CST. So he is the middleman between the companies and this CSD. He has agreement with the company's lordship. And that is their lordship. List of documents is there. This list page 76 and 77.
Whether that agreement that you have said,
Yes.
page number 74.
Yes. And our WS we have stated there.
Article 1, third paragraph, page 74.
Yes, lordship.
Where you have clarified.
That Sankalpa Consumer Privately Limited acting as an agent under so and so for making for after sale service for sale of their products to CSD. Company so and so has shown the expenditure in the balance sheet which was paid as transportation charges and booking of railway ticket to travel agent or agencies for the services provided to say so and so.
Now, just that is why we want to know from you whether this Sankalp Consumer Products Private Limited, you say that it was an agent under the agreement
Yes.
with different companies
Yes, lordship.
for after sale service. Right?
Yes.
It's been exhibited or it's been provided to the petitioner. These are documents. No.
List of document is here. There.
By which agreement? By which document? Wherefrom you are saying that it was the agent for after sale service of the suppliers? Which document?
Lordship is
Whether this bill of 198,829 was raised by Sankalp Consumer Products Private Limited from you?
no. That is not the allegation. Is that he had misused his official capacity. He had used this person to buy tickets and for hiring vehicles for his own benefit, own use. That is the allegation. Money they cannot taken for us, but he cannot take that money from that Sankalpa consumer. But because list of documents and all those hiring agents had sought for those payment from a Sankalpa consumer, lordship, list of documents are here, lordship. Those letters were referred by various service provider to Sankalpa that they had to pay on behalf of the petitioner respondent. List of documents is the vouchers are there.
tell us any such instances that this particular Sankalp Consumer Products Private Limited as a after sales service?
Lordship, here, Lordship, charges. Charges are there, Lordship, page number 213. It's in 4 pages, Lordship. Here it is stated that paragraph 2, that's Sri KK Srivastava has availed the convenience facility by way of railway tickets and hire vehicle for himself, for his family members and relative provided by Sri Milin Govlikar, director of so-and-so, without paying anything from his pocket. That the vehicle were hired by Sri Rabindra V. Chavan and booked the railway ticket in favor of KK Srivastava on or his behalf to his family members on the instruction of Sri Milin Govlikar, director so-and-so, from different travel agencies. So names of their lordship, the payment of vehicle hire charges and railway ticket has been paid to the travel agencies from the account of Messrs. Sankalpa Consumer Products Private Limited and Sri Kishore Kumar Srivastava have availed the pecuniary advantage in kind other than legal remuneration to the tune of rupees 1,68,616. The Sankalpa Consumer Product was acting as agent of different companies to CST. There was a written agreement in between Messrs. Sankalpa Consumer Products and Messrs. Timex, Dabur, Cadbury, Tata Tea, Prime Houseware, PepsiCo, Colgate, Haldiram, Adani, so-and-so for logistics support and after sale services for supply of their products to CST, again professional charges or commission. Milin Govlikar was looking after the CST business on behalf of Sankalpa and having interaction with so-and-so, which is his official dealing with CST. Said company has paid the commission or professional charges claimed by Sankalpa Consumer Products Private Limited and said payment has been received by the account of Messrs. Sankalpa Consumer Products. The company Sankalpa has shown the expenditure in the balance sheet which was paid as transportation charges to travel agent for the services provided to CJN Corp. That Messrs. Sankalpa Consumer Products Private Limited has shown the payment against bill of car hire charges and railway ticket in favor of KK Srivastava amounting to rupees 1,68,616 from account of Messrs. Sankalpa Consumer Product Private Limited. Car hire charges, air and railway ticket bill received from so-and-so. That's rupees so-and-so has been paid against billing amount of rupees 1,98,829 as convenience charges and booking of railway ticket and aforesaid travel agencies by Messrs. Sankalpa Consumer Product Private Limited. Detail is as lordship.
Yes. Adding part.
Lordship is taking up tomorrow.
Yeah. So how is not possible today?
Can it be next week, my lord? Or week thereafter?
Next week. Third.
Yes, my lord, third one.
Right over the support of meetings.
Is white milo, 12.71 gram milo recovered milo. And if that is so milo, it is milo intermediate quantity, just about the milo, small quantity milo. FIR is annexure 1, page 18 milo.
Earlier rejected or what?
Earlier, your lordship has, milo said that liberty has been granted to approve before the landed court below. Thereafter, my lord, I filed anticipatory bail, my lord, can be after filing of the search sheet, my lord. Because, my lord, as per my lord, FIR, my lord, if your lordship go to the page 18, my lord, last part, then I waited recover substance, digital weight, property, Bandodua OC, witness 12.71 gram. The above mentioned independent, the seized psychotropic substance were packed and sealed by me, independent witnesses. After completion of PO outpost, Khargeshwar Boro, so and so has been arrested. During interrogation, it is apprehended accused, namely Khargeshwar Boro, and admitted that seized suspect whom were brought from the person Ritul Huya, place so and so, my lord. And he collected somewhere, we got, he is the main drug peddler Bandodo area, collected suspected to be heroin somewhere in Laluk. Soon we rushed towards the accused person house, Ritul. Yeah, so and so, my lord, address, and whole operation was led by him. After that, we are able to collect Ritul here over telephone, asked about the suspected heroin, replied he have one softbox suspected to be heroin, will hand over suspected to be at Harmoti area. After we immediately contact Harmoti officer, conduct the operation, managed to apprehend Ritul here. Then these are the accused person where from the goods has been recovered. Suspected substance has been, psychotropic substance has been recovered. Then, my lord, after completion, all formalities departed from the one outpost along with he apprehended Ritul Huya, so and so. During interrogation, the apprehended accused, namely Ritul Huya of so and so, were delivered by Anna Khatun, Nogao, and Sajrul Haq. At that, I was not there, my lord. It is, my lord, they have also stated, as if you will also go to the Caesar list, Government of Assam registered so and so. Fazlul Haq is the IC, my lord, accused person in the instant case, my lord. So nothing has been recovered. Only on the basis of my lord co-accused statement, I made accused in this case, my lord. Subject to correction of my learned friend, my lord. And my lord, Anima Khatun and my lord, Sajima Begum, for whom, my lord, they have recovered, my lord, they are releasing on bail, my lord. And Khargeshwar Boro also released on bail. Ritul Huya is also released on bail, my lord. My humble submission. At that time, Khargeshwar Boro bail of the annexure 2, my lord. At that time, my lord, I was in Nogao, my lord. I have made categorical statement, my lord. It is also, my lord, as per record also that is stated, my lord. I was not in the place of occurrence. Only on the basis of post-accused statement, I made accused in this case. I am, my lord, some judgment, my lord. Yes, my lord. One is, my lord, Tufan Singh, my lord, paragraph 38, 42, my lord. So lordship kindly go. Then, my lord, 53, 50, I write down the, my lord, page number of the judgment, my lord. And one of our High Court, my lord, Loit Lam, my lord.
You have already given to us. Tufan Singh, para 3842.
Yes, my lord. Then,
Deepak Bhai Jagdish Chandra Patel,
yes, my lord.
para 5354.
Yes, my lord.
Other is of this court.
Yes, my lord. And anticipatory bail can be granted after filing of the charge sheet. That is the judgment, my lord. That is the-
Let me go to the records.
Yes, my lord.
We'll pass the order.
Yes, my lord. Nalag. Done. And one additional affidavit has been filed, my lord. Yes, my lord. The another case is pending, my lord, and that is also my.
Mr. Chaudhary, it will be listed on third.
Yes, my lord.
কে বসছে লর্ডশিপ?
Based on third. Based on third.